Good morning. My name is Hayward Dykes. I'm going to call the January 14th, 2026 traffic court docket to order. If you have a cell phone, please turn it off or put it on vibrate. The first case on our docket, I believe that's continued. That's for Beard. The Bradford matter's resolved itself, so we are on number 3, Hunter Conley. This is Officer Medrano. Is Mr. Conley here? All right, Mr. Conley, if you want to grab a seat at this first table right here. And just for everybody, so we'll allow the officer to present, and then you can ask the officer any questions that you may have, and then you'll be allowed an opportunity for testimony and any evidence you wish to present. All right? So, officer, and let me go ahead and get everybody sworn in. So if everybody will stand, we'll just do it all at one time. And stand, raise your right hand. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? All right, thank you all. You can take a seat. Officer, is it Medrano? All right, Officer Medrano, whenever you're ready.
On the left, you'll see on October 13th, 2025, at approximately 7:50 p.m., I observed a request of the fire to prevent use of fire. I then checked South Walton Fire Department's portal called ES every way that there was not one pulled for this book I could see. Please attach email from the fire department that was confirmed the next day on 10/14.
All right, so let me look at this. So on the docket, we have Mr. Conley listed 3 times. That's for each of these 3 citations you have. All right. Mr. Conley, do you have any problem with us just trying to do it all at one time, or do you want to be called up 3 different times for each citation? Okay, so we'll handle all 3 of these that are on the docket as one matter, but then I'll deal with each one individually when we get to the end. All right, so go ahead and present. Seems like they all stem from the same nexus of events. Is that correct?
Yes.
Okay, go ahead.
So the fire ordinance that was violated was 22-54 1A. That's that first reference word. Would you like me to?
What do you mean? Read the ordinance or read the?
The ordinance.
No, is this the copy that you provided to me?
Yes, it's
Okay. And do you have a copy of this, Mr. Conley? Did she provide that? Okay, good. All right. No, I don't need you to read it. Go ahead.
I asked the woman who was a participant of the fire who the he responded, "Hi, me." She said, and then I approached the fire. I observed a tin container buried into the sand. The violation of the ordinance that was violated B1F, and that's that last ordinance, the F at the bottom, that was violated. I then asked for ID and to extinguish the fire safely. I explained and tried to educate the violators of the ordinances that were broken. They did not comply at first. I then observed the participants using a metal shovel to cover and bury the fire to extinguish. The homeowner, Mr. Conley, stated they do this all the time. They will clean this in the morning. This is not only against the ordinance, but also a safety issue as the sand gets hot and it was at night. You could not visibly see where the tank container was buried. The ordinance that was violated was 22-54 B1E. That's that middle, the letter E there, that was violated. I also attach in this file Florida Statute 162, and that refers to I can give a citation when there's something unsafe that's happening. I then turned my camera off to speak with my supervisor to advise how to proceed. He stated to write a citation for every violation observed. I also have body camera footage available for evidence. I attached the property appraiser's website showing that Mr. Conley is the homeowner. There's that Florida statute 162.21 as well.
Okay. All right, Mr. Conley, I'll allow, do you have any questions for Officer Medrano at this time? Okay. Do you have any issues with me accepting into evidence any of the documents that Ms. Medrano's referred to? Okay. Officer Medrano, is this on private property or was this on the public beach access?
This is on private property in the area of the Seacrest beach area.
And so do you need a permit to do this on your private property?
Yes, sir. Per the ordinance, a fire permit has to be issued for each fire.
Then that would also include the part with the container, so you have to, whenever you get the permit, you advise what kind of container, you're advised what kind of containers are.
Per the ordinance, the fire department, the container has to be approved by the fire department, and it has to be at least 4 inches off of the sand.
So the fact that it was, you said it was a 10 container, what are the containers that are approved?
Yes, sir. So this container specifically was an oval shaped container. It is comparable to something an animal would feed out of. It was dug into the sand, so it was level with the sand at that point. Couldn't see it, so something that would be approved would be something with legs lifted off of the sand. It has to be, the bottom has to be completely covered with a metal plate so it doesn't drip onto the sand to leave remnants.
And then the no permit, that seems pretty straightforward based on the emails you received.
Yes, sir. I did look, and the participant at the fire, I think there was a little confusion. I think they had an annual permit, which all beach front owners, I believe, have to sign up for that annual fire permit per the fire department. However, each permit has to be pulled every night for a fire.
So explain that to me. So you can get an annual permit or approval, but then you have to go each time you want to build and advise, I guess, South Walton Fire District that you're going to do it. I want to do one tonight, and then I decide to do one Sunday. I got to come back and get another permit.
Yes, sir. You just alert them that you will be having a fire, and then they'll issue a permit for that night.
And it was under your investigation and your testimony that there was none pulled for this particular night?
No, sir. The participant said that someone from the property company had pulled the permit. Someone named Nikki. I also looked at the beach access near the home. If maybe there was one pulled for that access on accident. I looked at least 10 different ways.
And my understanding is when you get a permit, you're actually given, would these also be given a geolocation, so GPS coordinates, so you know where you're not on public versus private?
So the address, it's specific to the address,
okay.
The property address.
And then the cleanup, so the issue is they didn't clean up the fire. I mean, it would have been hot at the time, correct?
Yes, sir. So referring to that, this is during turtle season per the ordinance that I wrote the violation for. Mr. Conley stated that he'd get it cleaned up the next day and that they do it all the time. However, it's turtle season, so per that ordinance that they violated, all remnants for the fire has to be picked up by midnight.
And what time were these issued?
I got there about 7:30. I was there for over an hour.
So the citations state that they were all issued around 8:25 p.m.?
Yes, sir.
And do we know whether or not it was cleaned up? Did you go back out and investigate?
I'm unaware. There's also a violation of removal of sand that I did not write because I did not witness them removing the sand. However, that tin container was filled with sand to put out the fire, so the only violation I could write is the remnants violation.
All right. Thank you, Officer Medrano. Mr. Conley, do you have any questions based on my questions for Officer Medrano? Okay. Thank you. You can grab a seat. Mr. Conley, if you want to come on up. And one other thing, Officer Medrano did it fairly well. Just make sure you speak into the microphone. We
This one work?
Yeah. All right. Good morning.
Morning. Thanks.
Yep.
I guess I am here as a property owner. To explain my side of the situation, and also to ask for these to be reduced from the fines to warnings. And she mentioned the permitting process, and that was something that we did previously in the year to get a permit, which we thought was basically a permit if you wanted to have a fire at your property. And we have a property manager that helps us, and so we coordinated with her the previous week and said, hey, we're planning on having a fire. You make sure we're all set up. Her understanding of the process was that because we have, and I've got a picture of the permit, the permit that we got for the annual, if you'd like to see that. So we went into the process. We were having a small bonfire. The container that she referenced was not tin, but it was aluminum, which is one of the, I believe, approved guidelines. It was not 4 inches off the ground. I wasn't aware of that requirement. Historically, we do the fire, and when we put it out, as soon as it cools off enough, we can remove all of the remnants, and there's no damage to the beach. Everything's fine. And in fact, we did that. She asked us to remove it immediately, as you kind of suggested. It was probably several hundred degrees. We couldn't pick it up at that point because we just put out a fire that had been burning for a few minutes. And so as soon as it cooled off later that night, I removed it. 2 officers came by the next morning to inspect, and Officer Gum, and I didn't get the name of the other officer, but they could not find remnants of the fire anywhere. So again, as a property owner and taxpayer that was trying to do the right thing, we were also, there was no alcohol. It was a small get-together. The size of the container was probably 8 to 10 inches by 24 inches, so it's not like some raging out of control bonfire. It just feels like the confluence of factors doesn't merit an over $1,000 fine. And so I would ask that I understand better all of the rules now, and so I'd ask these to be reduced to a warning, and it'll never happen again. And I don't think if I have any other make. I would say there was some confusion early on with the when Officer Medrano got there, and because we thought we had the permit, because we had done it for the year, we checked with our manager, everything we thought was good. Again, we're on the beach not planning to have all of our paperwork there. And personally, the whole approach of her felt very aggressive and not like, just escalated a situation that didn't need to be escalated. And that was frustrating. We had just blown out candles for my son's birthday or eaten cake, and it's like coming in here with a heavy hand. And so just like that to be recognized as well.
So is it your testimony that you cleaned up the remnants that same night?
100%, and that can be confirmed. Apparently, the beach patrol sent 2 officers down the next morning to investigate.
And so, in the past, as
In
far
the
as
instruction to remove it, I mean, I wasn't disobeying, or it just wasn't possible at the moment.
understood. So on the permit portion of it, you have the annual permit, okay? And who handled? Or let me ask it this way: is this the first time you've had the annual permit?
Yeah, I've had the annual permit before.
And do you normally handle, or is it your management company that normally handles getting the permits or authorization from South Walton Fire District?
I have to fill out the form, get it notarized, and send it back in. So I do that part.
I guess what I'm talking about is you heard me earlier ask Officer Medrano about the annual permit doesn't provide that you can just do a fire anytime you wish, that you have to contact them and say, hey, we're going to do one tomorrow night or Friday night. Right. And then they issue you they issue the permit at that point. I guess my question is, you're familiar with the process, or are you familiar with the process?
I am now. I wasn't. I just assumed that you get an annual fire permit and it's your property, you can do it. And that was a misunderstanding on my part. And so I'm asking for that to be some leniency there, because it is a little bit of a confusing process, in my opinion. But I understand it now.
All right. Officer Medrano, do you have any questions for Mr. Conley at this time? Can you use that microphone? Just turn it on. Yeah, that one's fine.
Okay. So as many fires that you've had, you've never pulled a permit, and you've always done this with the fires, buried the fires to put them out. How do you usually extinguish a fire?
Usually we're there for a few hours and it just goes out. I don't know. I've probably done it 2 other times before this time would be my.
So you remove the sand from the beach?
You're asking a question I'm not sure the answer of, because it's like happens so sporadically. In the question of the fire that we had that night, you asked us to put it out immediately, so I didn't know any other way to put it out other than to. Is there any? I mean, how else?
The other way, typically you would use water to put it out, so it'd pull the tin, sand from the beach, or leaving remnants on the sand.
Okay. In the future, I'll do that. Again, it's like a very small container, so I think the beach is all right.
Any other questions, Officer Medrano?
Yes. Are you aware that other people walk on that sand in front of your property, even though it is private property at night?
Yes.
So you're aware that that would hurt someone's feet if they walk across that buried tin can, if they obviously couldn't see it.
All right, Officer Medrano, we're not going to go into speculation as to,
I wasn't, it's just like, it's just not aware, and that's why he wasn't trying to hurt anyone. That's just something that you think of, that's all.
Understood. Well, I don't know that he can.
I'm aware now, and I won't do it that way moving forward.
All right, anything else, Officer Medrano? All right, yeah. Mr. Conley, do you have anything else you want me to consider?
No, I think I'm good. Thank you.
You can grab a seat, sir. All right, I'm going to accept into evidence the Officer Medrano's packet, which included the citations, a printout of the applicable ordinances, as well as the statute 162.21, as well as the email and the Walton County Property Appraiser printout showing ownership of that property by Mr. Conley. And then there's one other detailed activity report, Walton County case report. So I'll accept all that into evidence. I'll close the evidence portion of this hearing. The first thing I'll do is I'll make a finding that there's been insufficient evidence to support a violation as it relates to the cleanup of the bonfire. Based on Mr. Conley's testimony, he testified under oath, which was uncontradicted, that he cleaned up the bonfire that same evening. There's no evidence to show that he didn't clean it up before 12 o'clock, which was, or midnight, which was Officer Medrano's testimony that it would need to be cleaned up by. So I'm going to make a finding that there's insufficient evidence to support that violation, so that matter will be dismissed. As it relates to the no permit, I do find that there was sufficient evidence to support a finding that no permit was issued as it relates to this matter. In that instance, there's a $500 fine, a $50 administrative fee, and a $25 clerk processing fee. While I understand Mr. Conley had confusion on the matter, there is testimony that he was familiar to some degree with the process. That $575, Mr. Conley, you'll need to pay that within 30 days. Is that going to be an issue? All right. As it relates to the container, the failure to approve a approved container, I do find that there is sufficient evidence to find a violation has occurred in reference to that ordinance. However, because of the circumstances, I'm going to reduce that from a $100 fine to a $50 fine. There's a $50 administrative fee and a $25 clerk processing fee for a total of $125. That will also need to be paid within the next 30 days. Are there any questions regarding the orders? All right, Mr. Conley, thank you for coming in this morning. You're getting a copy of the orders right now. You'll have 30 days. You can play that, I think, through the clerk's office. So you can pay it down at the Santa Rosa Beach Annex, or if you're up near Defuniak, you can pay it there. So you don't have to, there's no clerk's office here in Freeport. All right? And you're dismissed. Thank you, sir. All right, our next case is Teresa McCall. All right, Miss McCall, if you want to grab a seat, we're going to do yours just like we just did Mr. Conley's as far as the procedure goes. And we have Officer
Esquivel?
Esquivel. I wanted to make sure. Thank you, sir.
No problem, sir.
Officer Esquivel, whenever you're ready.
Yes, sir. I have distributed information packets for you and for her.
Thank you, sir.
So on the 29th of November of last year, while doing routine patrol in the Van Ness parking lot, I noticed not only her vehicle, but a lot of vehicles parked out of marked spaces within that parking lot. And they were all issued a citation under section 2012 of parking marked spaces. And I have the pictures there as to why I gave the ticket, how she's out of a marked space. And I do want to reiterate that she wasn't the only vehicle there at the time, as you can see in the pictures, for being issued a citation for being out of a marked space within that parking lot.
All right. And I have, provided by Officer Esquivel, 1, 2, 3, 4 photographs of a black Mercedes, as well as a copy of the picture of the citation that was issued, the vehicle search, Florida vehicle search printout, and a copy of section 20-12 parking spaces marked, as well as section 20-26 parking and spaces marked. Ms. McCall, do you have copies of all that? No, I'm talking about the packet that, yeah, I just went through it. Have you had a chance to go through it? I know, okay. Well, if you want to look through it real quick, I plan to accept that into evidence. If you have any objections to me accepting that into evidence, I'll be glad to hear those, but I intend to accept those things into evidence. I know you're giving it this morning.
I do want to point out that section 2026, sir, is was the outdated version of the parking spaces marked, so I did provide it there just in case there was any confusion. The 2012 is as of current, which is what's on the citation.
Yeah, I note on the citation that 20-12 is the code number identified for the violation. Anything else, Officer Esquivel?
No, sir.
All right. Ms. McCall, do you have any questions for Officer Esquivel at this time? Okay. Thank you, Officer Esquivel. You can grab a seat. Ms. McCall, if you want to come on up, and I'll be glad to hear any testimony or review any evidence you have. Either one, whichever one's working.
Okay,
Yeah.
is it like this
Yeah.
one's work? Okay. So I've never gotten a citation before for anything like this, but the reason I parked there, my grandson and I were going to go to the Christmas parade at Seaside, and there was really no other parking, but I would not have parked there if there'd been any parking signs whatsoever saying do not park. And even though I was parked along the curb, and I've got pictures of this too, the car behind me got a parking citation when we got back because we were only there for maybe 2 hours. But we took pictures of everything because I'm like, if I'm guilty, I'm guilty. But there were no signs in this county parking lot between Watercolor and Seaside saying do not park. Anything said no overnight parking, but we didn't see any other. So I'm really here for the principle of the thing. And I took pictures of other cars there, and I'm sure, they rotate around and they put citations at different times. I'm sure that's what happened. But there were plenty of other cars there parked along the curb everywhere that had no citations. Maybe they got them later or whatever, but I do have pictures. And my thing is, if we're not supposed to park in that parking lot, even though there's marked spaces, there's curbs everywhere, and there's hardly any place to park in that area anyway. So we need some signs if we're going to get citations for this. And for $125 when there's no signs, that's my complaint. And I'm asking for you to not fine me today and put up some signs if that's going to be the rules from now on.
All right. You said you had some photographs you wanted me to look at, or do you?
Yes,
Oh,
I
they're on your
do.
phone?
They are.
Well, I can't take your phone.
Okay.
Unless you want me to take it, and we can put it into evidence, but.
Might need it.
You might need it. All right. Officer Esquivel, do you have any questions for Ms. McCall?
No, sir.
Okay. Anything else, Ms. McCall, you want me to consider?
No, sir, that's all I've got.
All right. Thank you, ma'am. You can
Thank
grab
you.
a seat.
Thanks.
I'll accept into evidence, as I stated earlier, Officer Esquivel's packet. I'll close the evidence portion of this hearing. I'll make the following findings: that based on the testimony and evidence presented, that there is sufficient evidence to find that the violation of the infraction charge for parking outside of marked space has been proven. Accordingly, there's a $100 fine, a clerk administrative fee of $50, and clerk processing fee. And I'll just say, Miss McCall, I appreciate you showing up this morning. We often do have people who suggest that there should be more signage, that it should be facing certain ways. I've heard several excuses as to that, and I'm not suggesting that there's not a parking issue down there. I know for a fact there is, and that's part of why they've gone to this type of enforcement, is to try to alleviate some of that. And it does present a safety issue if, you know, heaven forbid, there's somebody down there that needs a medical services, they can't get those vehicles. So I don't fault you for that. I hate that you're here, but I do have to follow the ordinances as they're written. So you'll have 30 days to pay, and I appreciate you coming in, Ms. McCall. As long as it's not legal advice, I can maybe try to answer it. There's no requirement that there is an ordinance. Obviously, if there's parking spaces, it'd be the same thing if somebody parked over 2 spaces and says, well, you know, is there a sign that says not to park over 2 spaces, right? So, no, yeah. It's an issue, and it's not your fault. I mean, it's I guess a byproduct or just growing pains, whatever you want to call it, of all the growth and the individuals down there. And we're all trying to get our hand. I mean, otherwise we could have no parking signs everywhere, you know, and then people would complain, why do we have so many signs? So that's not my call. I mean, you can get with the county commissioners. They want to change the ordinance, fine. Give me the ability to, or give these officers the ability not to issue citations, and great, we wouldn't be here. But you know, we do have to, you know, enforce what's on the books, so to speak. Yeah, understood. Yes, ma'am. Thank you, ma'am. You're dismissed. The last matter we have is Haley. I'm just going to use the last part because it looks like there's several names. Haley Dowling, Dowling. Okay. Ms. Dowling, if you want to grab a seat over here.
Can I represent her?
No, sir, you can't. Unless you're an attorney.
I'm not.
Okay, then no, you can't represent her. All right. And then on this one, we have Officer Ford. And Ms. Dowling, you saw how we're going to let Officer Ford go first. I'll let you, give you the opportunity to ask any questions, and then you'll be able to present any testimony or evidence. All right. All right. Officer Ford, whenever you're ready.
Good morning, Your Honor. On approximately November the 17th at approximately 2:30 p.m., excuse me, while I was conducting a routine security check of Pilchard Park, I observed a vehicle registered to Miss Dowling parked in a clearly signed and marked handicap parking space with no visible permit displayed. I exited my vehicle to take evidence of the violation of Chapter 2012 of the Washington County Ordinance, and I have those photos as an exhibit to present for the county, which I've given Miss Dowling a copy as well. While I was taking the photos, Miss Dowling did approach me with a permit in her hand. I asked her if it was her permit. She said yes. I asked to see the identification card, which goes with the permit as required by Florida Statute 320.0848, which time she said it was her mother's permit. I then asked if her mother was present with her. She said no. I explained to her that that was constituted fraudulent use of a permit under subparagraph 12 of the Florida statute. I then compared the placard identification number to her driver's license number. They were not the same. So in that instance, I issued the citation against Section 2012 of the ordinance per standard policy.
All right. You want to go ahead and provide those photographs? Thank you, sir. All right, I've been handed 3 photographs. One is a picture of the vehicle from the front. The other is a picture of the vehicle from the back, a black Toyota. And then the third is a picture of the driver's license as well as a placard that Officer Ford was just referencing. So Officer Ford, or I'm sorry, Ms. Dowling, do you have any questions for Officer Ford at this time? Okay. Officer Ford, so it wouldn't be illegal or improper to have the placard should the mother be there, and she could use it on different vehicles. So you can take the placard and put it on vehicle A if the mother's with you, and then if the mother had to get in vehicle B to be taken to the store, she could use the placard there.
Yes, Your Honor, that's correct. So the placard goes with the person, and the person must be being transported in the vehicle in order to use that placard.
Understood. All right, I just wanted to make sure the record was clear that if the owner of the placard is present, it's not vehicle specific, it's person specific.
Correct.
Understood. All right. Ms. Dowling, any question? Hold on, Mr. Ford. Or Officer Ford. Any questions based on my questions that I just asked of Officer Ford? Okay, great. All right, thank you, sir. Unless, do you have any objections or that you wish to express, Ms. Dowling? I'm going to go ahead and accept into these 3 pieces, or these 3 photos. All right, I'll accept that into evidence at this time. Ms. Dowling, this will be your opportunity. If you don't mind coming up to the microphone, we do record these hearings, and this will be your opportunity for me to consider any testimony or evidence.
Yes, sir. So Officer Ford stated in the beginning that the placard was not displayed properly and that I brought it to him. I just want to say that it was displayed. I didn't have it hanging on the mirror because it doesn't fit on it, so I had it on the dash. I did not have it it wasn't in my person or on my body. And I said that it was my mother's, but I was incorrect. Both of my parents are handicapped. It was my father's, and he was there, but he was on the water that day. That's who's with me here. It's his ID that's on that, and Officer Ford didn't ask who had driven the car or who had parked it. I did not. My father did. My mom was with us as well, so I was unsure whose it was at that point. And I didn't think to call my dad because when Officer Ford got out of the vehicle, the first thing he said to me was that I was lucky he wasn't calling a sheriff to take me to jail for 60 days and a $500 fine. And I've never even had a parking ticket before, and that scared me a lot. So I didn't think to call my dad. And that's about it there.
All right, so your testimony is your mother was there?
No, she wasn't there. We had dropped her off previously. What I told Mr. Ford. It was my dad's. It's actually my dad's parking permit. And he was there, but he was on the water, so I didn't call him.
What do you mean he was on the water? Was he out on the fishing pier?
Yeah, he was out, fishing, because that's what we were there to do. And I was eating lunch there.
All right. And you have your father here?
Yes,
Do you want to
sir.
testify?
Yes, yeah.
Okay. What's his name?
Michael Dowling.
All right. Before we hear from Mr. Dowling, Officer Ford, do you have any questions of Miss Dowling at this time?
No questions, Your Honor, except that I was attempting to explain the and that's the reason. And when she placard, that's when I explained to her the second-degree misdemeanor with up to $1,000 fine and 6.
Okay. The, understood. Thank you, sir. All right. So if you have no questions for Ms. Dowling, I'll go ahead and hear at this time from, Mr. Michael Dowling. Well, if you wanna, he's your witness, so I don't know how well you'll be at asking him questions, but if you wanna ask him questions about this being his placard and him being there that day, why don't just grab a seat? I'll do it.
Okay.
Mr. Dowling, you've been sworn in?
Yes, sir.
All right. Go ahead and explain, you heard your daughter's testimony that this is your placard and you were there that day.
Yes, sir.
Go ahead and explain, to us, that, or testify as it relates that this is your placard, you were there that day and you, were being transported in this vehicle.
Yes, sir. I drove the vehicle there. I parked the vehicle there. There's several, there was a group of us, multiple cars. We had a boat. My daughter, they wanted to have lunch right away, so there's a little barbecue stand right there. So they were cooking dogs. When the officer showed up, I went out on the water in the boat fishing, and I didn't see any of it happening. Otherwise, I'd have came back. But yeah, it's my placard. I parked it there.
Okay. And then when you, so you didn't know about this until you returned?
I didn't know about it till I returned, and she was in just a ball of hysteria. He had her so scared, you know.
All right. All right. Officer Ford, do you have any questions for Mr. Dowling?
No, Your Honor.
All right. Mr. Dowling, do you have anything else that you want me to consider?
Nothing.
All right. You can grab a seat, sir. Officer Ford, did you do, I understand that she told you it was her mother's placard. Is there a way for you to check who the placard's issued to?
No, sir, not with our computer system. She first said it was hers. That's what precipitated the whole issue. She said it was her placard. Then she said it was her mother's placard. Then she said her mother was not with her present that day. So she precipitated the entire chain of events with her statement to me at the time.
No, I can see how that would be very confusing as you're trying to investigate the matter.
And of course, her father wasn't there, so I only saw the two young people sitting at the table. I assumed she was the only person there in the party.
All right. All right, I don't have it. I appreciate that, Officer Ford. Do you have any questions, Ms. Dowling, on those questions that I just asked Mr. Ford about, or Officer Ford? All right. And Mr. Dowling, come back up for a second. So just so I'm clear, it's your testimony that you were being transported in this vehicle, and I think your daughter's testimony is you actually drove that day?
I did drive and park there.
Okay.
You know, I'm on the registration as well, so my name would have matched the tag if on the little yellow tag that says whatever year 28.
Yeah.
Is my driver's license numbers on that tag.
All right. Thank you, sir. Well, hold on one second. Officer Ford, anything? All right. Thank you. All right. I've already accepted into evidence the Officer Ford's materials. Before I close the evidence portion, Ms. Dowling, come back up one last time. Can you explain the reasoning why you would have told Officer Ford at the time that that was your placard and not your mother's or your
I
and
had
your father?
misspoken. Like I said, the very first thing that he said to me was that I was lucky he was not calling a sheriff to take me to jail, and I panicked. and I misspoke on that. That it was mine. I did not mean to say that.
Because you don't have a
I
placard,
do
you're
not,
not
sir. No.
disabled
No, no.
or
No, no.
been deemed disabled. Okay. All right. Thank you, Ms. Dowling. All right, I'll close the evidence portion of this hearing. What do you need? Oh, I thought you were reaching. Say again? Oh. No, it's just, there is a driver's license. It's not hers. What's the last four of your license, Mr. Dowling? Well, I looked at that. I can't hardly see it on there.
The last four on his is 0630.
Yeah, you might have better eyes than me. The last four. It looks like 06.
0630.
Yeah. Yeah, it's blurry, but it appears to be either a 6 or a. No, yeah, I understand that. It looks like she might have some other things hanging from that as well. So. All right, thank you. I'm gonna close the evidence portion. I think I reopened it there, so I'm gonna state that I'm reclosing it. Based on the testimony and evidence presented, while I understand Officer Ford, I believe, did have enough probable cause to issue the citation, I believe based on the testimony and evidence presented this morning, that there is insufficient evidence to support a violation as cited. I believe the uncontradicted testimony that this placard is Mr. Dowling's. He testified under oath that he was transported in this vehicle, even though he wasn't around the vehicle at the time. Why Ms. Dowling, I think, based on her statements to Officer Ford, I guess escalated, for lack of a better term, and I can understand why Officer Ford issued the citation because of the confusion that you provided to him at the time. But that's why we have these hearings, to try to sort some of this out. So I don't fault Officer Ford for the citation, but I do believe, based on Mr. Dowling's testimony, and it does appear, from what I could tell, even though it's blurry, the placard, the license number listed on the placard does appear very likely to be Mr. Dowling. So based on all of that, I'm going to order that there was insufficient evidence to support the violation as cited, and the case is hereby dismissed. All right. Officer Ford, I appreciate you coming in this morning. You're dismissed. And Ms. Dowling, you are also dismissed. Thank you. And that appears to cover our traffic docket for this morning, and we are adjourned. If you have a cell phone, please put it on vibrate or turn it off. And at this time, we will go ahead and do the Pledge of Allegiance. So if you can stand with me, we'll do that. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. If you can grab a seat. I've reviewed the minutes and have signed those. Are there any announcements regarding anything on the agenda today? Okay, no announcements. At this time, anyone who plans to present any testimony or evidence this morning, these are quasi-judicial hearings. So anyone, again, who plans to testify or present evidence, if you'll please stand, I'll swear everybody in at one time. All right? And if you don't think you will, and you decide you are going to present testimony, then we'll just need to address that later. All right? So do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. You can grab a seat. All right. Our first case this morning is 250063. The property owner is listed as Amy Machado. Is Miss Machado here? All right, Miss Machado, if you want to come up, you can grab a seat at this front table. And this is for everybody this morning that's here on a matter. We allow the county to present. You can ask questions of the officer, ask questions about the evidence, and then after that's done, we'll allow you to present any evidence or testimony you may have. Do we have Ms. Machado's stuff up here?
I put it number 11 and 12 on the agenda. I don't know if we
Yeah, I've got Miss Machado as number 1 for SDR. Oh, all right. Well, I'm sorry, Miss Machado. You're actually. So this is the right agenda? I thought this was the agenda. All right. So, Miss Machado, I'm sorry. You're going to grab a seat. I've called you out of order. I know you were excited to get done, but they told me I was wrong. So you were first on the agenda I printed up. So, all right, I apologize for that. So actually, our first case is 25-01814, and the property's listed as owned by Amanda and Clifford Bright. All right, great. If you guys want to grab a seat there. Whenever you're ready, go ahead.
Okay. I'm a co-compliance officer, Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 25-01814. This property is in the unincorporated area of Walton County, subject to Land Development Code according to Florida Statute, Chapter 162, under parcel number 24-2 S Sierra 2142274000290, also known as 31 Cosmos Court, Santa Rosa Beach, belonging to Amanda G. and Clifford Bright. The violations listed will be 1.1306 post-permit changes and 1.13.09 C building permit. Complaint was received on 10/6/2025 with a initial inspection showing under Exhibit 1 and direct contact with the owner made at the site on 10/7/2025. Mr. Bright was advised of the reason for my visit and there not appearing to be any permitting for the screened-in addition on the south side of the residence. Let's see, after visiting the property, I completed further research showing in Exhibit 5 in reference to some storage buildings, and I observed the potentially be in the rear setbacks and any historical permitting with no historical permitting or variances granted. On 10/10/25, a notice of violation showing in Exhibit 3 was prepared giving until 12/9/2025 for compliance and placed in certified mail. Then posted on the property on 10/14/25. with me briefly speaking to a female resident while posting the notice and advising of her process, along with speaking with Mr. Bright on the phone shortly after leaving the area. There was continued monitoring of the county portal, showing no updated plans for review, along with inspection showing no visible changes and removal of the unpermitted structures in Exhibit 2. And on 12/17, determination was made to move forward with a notice of hearing. Certified mailing was sent out and posted at the property and the courthouse on 1/14/20, for the hearing for 1/14/2026. On 1/12/2026, I received photos from Mr. Bright showing he had removed the storage buildings from the rear setback. He requested a moving from the docket after taking this action, but I advised if the south side addition remained to be present with no permitting, I could not grant the request. On 1/13/2026, a pre-hearing inspection was made, verifying the removal of the sheds, but the unpermitted addition on the south side of the residence remained, shown in Exhibit 6. With observation of the removal, I did take off the setback violation as being resolved. And as of right now, I'd like to submit my packet and findings as evidence.
Mr. and Ms. Bright, do you have a copy of the Officer Forehand's packet? Do you have any comments or objections?
That is not what we received certified, not coincide with what we received.
Okay, that's fine. I'll note your objection, but I'm going to accept it into evidence. And the one that you just held up was Exhibit 5, the aerial image. Is that correct? All right. So
All we received was the top portion.
understood. I'll go ahead and accept this, though. I mean, you're not disputing that that's not an aerial of your home?
No, sir.
Okay. All right, I'll accept the county's packet into evidence as submitted. Do you have any questions for Officer Forehand at this time, whether it be about the packet or anything that he's testified to this morning? Okay. Officer Forehand, thank you. You can take a seat, and either one of you or both of you can come up. Now, we do record these, so I'm going to need you to come up to the microphone, please.
I do know that ignorance of the law is not an excuse, but when I initially erected the buildings, I read the code that said anything under 200 square foot did not require a permit. I was recently informed that is not the case. There's a little bitty fine print that actually says that if you're south of the bay, it does require a permit. When I contacted planning and zoning, and unfortunately I did not take the lady's name down because I was in the middle of a work day when I talked to her, she gave me the weirdest answer saying that you're not technically required to have a permit until someone files a code compliance case against you, if it's under 200 square foot. She did tell me, however, that they would not permit anything within the 15-foot setback behind the home. So which is why we removed the 2 storage buildings that were sitting behind the house. Now, we did not see anything in reference, like I said, and I can show you what was sent out to me, truly in reference and highlighting anything regarding a structure on the side of the house versus the aerial photos and everything. And I would like to also submit into evidence the fact that the first time I met him, he told me he used our easement to walk to look on the south side of my house, which is not visible from public view. In order to view the side of my house and take all the pictures he took, he had to trespass onto my property to do so.
Well, hold on. So what's this easement for?
So if you look at this photo right here,
No, I understand your, I'm
so if
sorry.
you look at this photo right here, he claimed that there was an easement here on Exhibit 5, the top picture.
Okay.
He claimed that there was an easement in between my house and 30 Cosmos Court, which I explained to him that day, no, sir, there is not an easement. Our property lines touch. So if you walk down that driveway to look to the south side of my house, which is not visible from the road, you trespass, or I didn't tell him that day he trespassed, but I told him he did walk onto my property to look at what is not visible from the road. When he came out yesterday, this time, he didn't even walk through that grass. He walked right down the middle of my driveway, which I do have pictures of him standing in the middle of my driveway, walking onto my property, and on my property of him standing out in front of my fence that is not visible from the road, taking pictures of my private area, which is a violation of the Fourth Amendment and proper search and seizure, because he did not have a warrant to enter my property to look onto the south side of my house. I also have pictures that show you the actual view from the street of how it is to my house, and it's over 60 foot to walk from the edge of the property onto my property to look at the house.
So you're gonna introduce those photographs?
Yes, sir.
All right. You wanna show
Unfortunately,
those?
I didn't get copies for him. I didn't think about getting copies for him.
Okay, show them what you do have.
There are photos from the edge of my driveway and the neighbor across the street to my driveway that looks at the private side of my house where you cannot visibly see on the side of my house, and the picture of where he walked all the way onto my property to look on the invisible side of my house.
All right. I'll accept this into evidence as respondents composite exhibit A. These are 1, 2, 3, 4 photographs introduced by Mr. Bright. Okay.
And I would also like to make the statement that the reason he came out in the first place was a falsified complaint filed against me. The address the Ryan Story provided as the house he lived in, he does not live in. And if he would have talked to the owner, would have realized he was kicked out of that house for doing drugs. And the fact that he claims that I've had multiple violations from my association is also falsified. I am the HOA president, which I also explained to the officer the day he was there, that he was out investigating me based on a falsified complaint.
Okay. What do you mean falsified? What's falsified?
He lied about where he lived, and he lied about the fact that I had received violations from my association. Now, I did comply and have removed from the buildings. I do ask for leniency on the other, because again, from what we received, I was not aware that I was supposed to have something done about that, but I have contacted a contractor who's actually coming out today that is going to help me either make it to where I can get it permitted, and if it not, then I will remove it.
All right. Thank you, sir. Officer, hold on 1 second. Officer Forehand, do you have any questions for Mr. Bright regarding his testimony or the evidence he's presented? Okay. All right. Well, I'll need you to come up to the microphone, please. Mr. You can just stay there. You can use that one.
As if you look in our packet, the first day I met, for the reason I responded out there, in my notation on my initial inspection, it states where we were made contact, and I advised why I was out there, and saying he pulled up as I was going to leave, asking if there was any issues, and I explained the complaint that we received, complaining about the addition and potential concerns. And he advised that the addition had been there at least 10 years with him building it while his father was battling cancer. So we talked in depth about why the addition was over to the side and covered. And he asked who made the complaint, and I referred him to our administrative staff to find out who made the complaint. And let's see here.
So, Officer Forehand, do you have any questions?
Yeah, okay. I'm
of
sorry.
Mr.
Yeah.
Bright?
But do you recall us talking about that and me discussing the addition and you saying you added it on or covered it to, for your
Okay,
father.
because when we purchased our house, there was
Mr. Bright,
actually,
if you don't mind,
we actually purchased our house, there was a large storage building that was there, that in the purchase of the house, there was never anything said that, about it never being permitted or anything like that. So all I did was actually convert it into a screened-in porch for my father-in-law when he was dying of cancer. So the building was already there when we purchased the house. And there was nothing brought up in the title company or discovery or anything that said that building was unpermitted. And that's what I explained to him when he was there.
But there was discussion of, that's why I was there.
But that
was
did not give you
addition.
permission to walk on the property.
Oh,
I never
yeah.
gave you permission, and my wife actually asked you to leave property yesterday,
I did.
and she said that you were literally giggling and laughing at her because she can barely speak when she asked you to leave the property, and that you continued to stay on the property and take pictures instead of leaving immediately.
I took one photo and left immediately, removing the sign that you requested me to remove from the property. The day before, you gave me permission to go on there and remove that
To remove
sign.
that sign, yes, sir.
Yes, sir.
But even truthfully, if you're looking at all these photos, you either had to walk onto the property or my property.
Yeah,
or
I took
other
one. I
properties.
did take like one step beyond the. I'll admit, taking one step beyond the concrete of the parking area, the driveway.
Okay.
Which-
Again, Officer Forehand, so we can wrap this up.
Yeah.
Do you have any additional questions for Mr. Bright?
No, sir.
Okay. All right. Is your wife wishing to testify, or does she need to, I mean, unless she has something extra to add, I mean, it's your call. Okay. You don't have to. I'm just gonna give you the chance if you want it. All right. Okay. Anything else, Mr. Bright?
No, sir.
Okay. I do have a question for you. You said you have reached out to planning.
No, I have reached out to a contractor who is
Oh,
coming
okay.
out today to just check my work and what I did to make sure that it's going to fall under code and be passable and inspectable and permittable. And if it's not, then we're gonna remove it.
Understood. Okay. Did you want to speak to her? It sounded like she wanted.
She's
Okay.
wanting to stop at planning and zoning and start the permitting process. when we leave.
Understood. Okay, well, that's separate and apart from this.
Yes.
I was just asking the question. All right. Officer Forehand, any other questions for Mr. Bright based on those couple questions? All right, thank you, sir. Officer Forehand, anything additional?
Recommendations. I got the recommendations here of, our staff recommends a maximum of, or 62 days till March 17th of 2026 to obtain the permit for the addition or removal if not granted, and $100 a day thereafter until brought in compliance. And today's admin fees are $73.
All right, thank you, sir. Mr. Bright, you've heard the county's recommendation. In the event that I find that there's a violation, there's recommending that you have 62 days to bring the property into compliance. That would either be removal of the structure or have it permitted. In the event it's not done with timely, it would be $100 per day moving forward, and then there's a $73 administrative fee. Do you have anything that you would request based on that recommendation? Again, haven't made a finding yet, but that's just what they're going to ask for.
Yes, sir, I understand that, and I have no problem with that. The only thing I would ask would be to not charge the filing fee since you did press that.
You mean the admin fee? Okay, understood. All right. All right, thank you both. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 31 Cosmo Court, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Pursuant to that, I believe there is sufficient evidence and testimony that was presented today to find a violation of 1.13.06 post-permit changes and 1.13.09C building permit requirement. it sounds as though the Brights are taking steps to remedy this issue, and while there is some question or testimony that could bring up the question of some of the photographs that Code Officer Forehand may have taken, there are the aerial photos that are from the property appraiser's website that were introduced that also show the structure that we're talking about today. So I do find that even if I excluded some or all of Officer Forehand's photographs that he took, there is sufficient evidence to show from the property appraiser's website that there is a structure located attached or adjacent, very closely adjacent to your to the home. With that being said, understanding how long it takes sometimes to have the contractor come out and review and go through the permitting process, I'm going to provide you the maximum amount of time, which is 90 days, to bring the property into compliance. Doesn't mean that you'll get it in compliance in 90 days, but the hope is that you say that again. So you'll need to bring your property into compliance on or before April 14th. In the event the property is not brought into compliance on or before April 14th, there will be a $100 per day fine imposed. There's also a $73 admin fee, and Mr. Bright, I can understand your request, but I'm not going to waive that fee. You will have 30 days to pay that. And keep in mind, you know, if you bring the property into compliance, then there will be no fines assessed. It's only if we roll over to day 91 that the fines will assess. In the event you do go over, there is a mechanism and a process where you can seek a fine reduction, and hopefully you won't need that, but there is that option. So I have signed that order. Do you have any questions, Mr. Bright or Mrs. Bright, regarding the order?
The only question I would have is, like you said, it could time in the process of getting permits.
No, sir, it will not automatically extend the date. If you overshoot that date, my recommendation is you continue to go through the process, finalize that process, and then speak with the county about how you get a fine reduction. And at that point, whether it's me or some other magistrate that's here, they can consider what steps you were taking and how timely you were, right? I guess there would be less sympathy if you decided to go apply for a permit on April 13th, right? So I just, I'm giving you the maximum amount of time I can, which is 90 days. And that's approximately 30 more than the county had requested, but I think that's appropriate considering you're getting the contractor out there and you're going to have to make a decision one way or the other on what path you're going to take. All right. Any other questions? All right. Officer Forehand, any questions regarding the order? All right. Thank you both. And that concludes that matter.
That for me?
No, it's not for you. They're going to enter it. You'll get a copy, and then you can, and you can pay that $73 in the next 30 days, and I think you can pay it at the. All right, thank you all. All right, the next case is 25-01697. It's listed as the property owner as the estate of Charles Currington. Is someone here from the Currington estate? All right, I don't see anybody standing. All right, whenever you're ready.
Right, my name is Officer Uriel Baza with Wong County Code Compliance. For the record, I am submitting my final summary case report and testimony regarding case number 25-01697. Property address is 281 Piper's Landing Road, Defuniak Springs, Florida 32433. Parcel number is 01-3-North-20-28011-000-0120. Property owner is listed as the estate of Charles W. Currington. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter I wrote the wrong number, Chapter 7 and the county ordinances. The violations cited are 2.02.00P, RVs and campers, and 5.07.09C, exterior storage of non-operating vehicles, junk, or debris. Complaint was received on August 22nd, 2025. People are living in an RV in a second driveway, and the property is in a mess. Inspection was done on August 25th, 2025. Conducted my initial inspection at the property. I was able to speak to Crystal Currington, who stated she was the property owner. At the time of the inspection, I observed several items lying out by the RV, which Ms. Currington did admit was being occupied and being lived in until the individuals could find somewhere else to place it. I informed her of the violations cited, which included living in an RV and the junk and debris. On August 26, 2025, I hand-delivered a notice of violation to Ms. Currington, stating the violations, the corrective actions necessary to bring the property into compliance, and the compliance deadline of September 30th, 2025. I have conducted several follow-up inspections on the property where I observed slow progression and then also regression with the junk and the debris. A notice of hearing was mailed on December 16th, 2025, posted on the property December 17th, 2025, and posted at the South Walton Courthouse on December 18th, 2025. As of today, January 14th, the property is not in compliance with the violations cited. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
That'll be accepted. What's the county's recommendation?
Recommendation is 30 days to cease living in an RV and to remove and properly store all items throughout the property that are visible by public view. If the property does not come into compliance, $150 per day fine to accrue, and then we also have the $62 admin fee.
All right, thank you, sir. All right.
You're welcome.
I didn't see anybody come in, but I'll do one last call. Anyone here on behalf of the estate of Charles Currington? Or if Miss Crystal Currington? All right, not seeing anyone. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 281 Piper's Landing Road in Defuniak Springs, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code in Chapter 7. Based on the testimony and evidence presented, I do find there is sufficient evidence to support that a violation occurs on the property, specifically a violation of 2.0200P, RVs and camper living, and 5.07.09C, exterior storage of non-operating vehicles, junk, or debris. Based on the county's recommendation, I will provide that the property must be brought into compliance within 30 days. That would be, all right. All right, on or before February 13th. In the event the property is not brought into compliance on or before February 13th, a $150 per day fine will be imposed. In addition to the fine, there's a $62 administrative fee. That fee will need to be paid within 30 days. I've signed that order. Gina, make sure you grab these from that first hearing on the Brights. I'll leave it up here by these orders. All right, thank you, sir.
Thank you.
All right, our next case is 2501880. Property owner is John Harrison. Is Mr. Harrison here? Anyone on behalf of Mr. Harrison? Okay, not seeing anyone. All right. Whenever you're ready.
Good morning, Your Honor. Officer Harold Serrano with Walton County Code Compliance. For the record, I'm submitting final summary case report and testimony in regards to case 25-1880 on behalf of Officer Rachel Neenan. She is here. She's just under the weather. Her voice is hoarse, so I'll be presenting this case. Property location is Rock Hill Road. Currently does not have a physical address. 911 address is record to be 796 Rock Hill Road, Defuniak Springs, 32435. Parcel number is 12-1N -17000-001-0050. Property owners to be John and Grace Harrison. This property is in the unincorporated area of Walton County and is subject to Land Development Code Chapter 7 and the county ordinances. Violations cited is 1.13.00A, development approvals, 1.13.09C, building permits, 1.13.09F, clearing permit, 2.02.00P, RV and campers, 2.02.03 is estate residential, and 2022-18 outdoor events ordinance. Original complaint, tiny house trailer has been moved onto property with people living in it without the proper permits. Complainant spoke with occupants and is concerned because they stated that they're going to be building a homestead farm or tiny home community for homeless and rehab individuals, for which nothing has been permitted. Also stated that they are erecting an 8x4 sign. Inspection on 10/29/25, Officer Neenan conducted an initial inspection and found a new signage board out by the road beside the mailbox. The possible easement has been cleared and gated with no trespassing sign. From the gate, Officer Neenan could see that there are structures, a tractor, a car, RV, and an RV on the property. From the aerials, it shows that the property has been cleared in some areas throughout the property. On 10/29/25 as well, Officer Neenan sent out an NOV to the property owner by certified mail and posted it to the property. On 10/30, Officer Neenan received a call from Grant Floyd and explained violations. On 11/4/2025, Officer Neenan conducted a follow-up inspection and posted a new NOV to the property, adding the outdoor events ordinance, as well as a notice to remove the sign in the right-of-way and a stop work order to stop the clearing and development. On 12/2, Officer Neenan received a voicemail from Mr. John Harrison at the number of 305-898-7233, returned his phone call and explained all violations to him, and he said that he would contact planning to get things corrected. On the same day of 12/2/2025, did more research. Officer Neenan did more research into the events and found that they are promoted by Floyd Moneyweather. Officer Neenan went to the website listed on the flyer, ancientbeachfarms.com, and seen the address listed in 796 Rock Hill Road. She then believed that the man she spoke to at the opening of the case, who called himself Grant Floyd, is the same person. When she spoke to John Harrison, he stated that Floyd has been terminated. The website is still up, doesn't appear to have any more events ads online. Officer Neenan was able to locate the Sunbiz for Ancient Beach Farms and Adventure LLC, who has registered agent as Grant Floyd and authorized person as John Harris. Officer Neenan emailed John Harris after finding these items and listed all violations that will be needed to be corrected. On 12/9/2025, Officer Neenan conducted a follow-up inspection and found the structure still on the property and no applicant submitted to planning for the clearing or structures. On 12/16/2025, Officer Neenan sent a notice of hearing to the property owner by certified mail and posted it to the property. On 12/18, the notice of hearing was posted to the courthouse. And 12/22/25, Officer Neenan received an email showing that the notice of hearing was delivered and signed for. On January 13th, 2026, a pre-hearing inspection was conducted and found that there is still what looks to be 2 enclosed trailers, a structure, and a Connex box on the property that is viewable from the right-of-way. Photos in your package show the initial inspection and pre-hearing conditions with violations still existing, and we would like to submit this packet into evidence.
All right, that'll be accepted. Explain to me, I understand the citations to the other sections of the code dealing with development approval, building permits, clearing permits, RV campers. What's the violation on the estate residential? Is that just an unpermitted use?
The state residential was for the event planning that they had advertised for the ads on the website.
And then the outdoor event ordinance, 2022-18. I mean, I guess if they're not doing any more outdoor events, there would be nothing to remedy there, right? Do we have any evidence they're continuing to or trying to do?
Correct. There seems to be.
So with them still having the website up and they're still in the process of planning those, I wanted to go ahead and have it on record that they have the potential to still advertise. They're still advertising online that they have that business there, with the potential of planning more events.
Right. Well, I mean, I guess.
And the estate residential was for the changing the use of the property with the events and with the buildings because it's currently supposed to be vacant.
Right, and wouldn't that be subsumed by the other violations, the clearing permit, can't have campers out there, development approvals, if they're using the property incorrectly for events? I mean, they'd have to get it changed, zone changed.
Yes, sir. It just depended on which direction he wanted to go. So I wanted to make sure that we were fully covered with violations in case he was to remove everything and he got the clearing permit, but the special events or the outdoor events were still being posted, that we kind of made sure that the use was also being shown as well as just for the special events.
Right. Well, I guess my concern is, unless he's doing events, he can post whatever he wants and say, I'm going to have a concert, and never has a concert. So, I mean, I guess my thing is, I would lean towards maybe, if anything, on those two, maybe saying that there was previously a violation that has been remedied, and that in the event he tries to do, no pun intended,
Yes, sir.
he tries to do something in the future and have an event out there, then you can bring that matter back in an expedited way.
As a repeat offender.
Right.
Yes, sir.
But I mean, unless there's a future event, I don't know that there's been testimony to say he's continuing to.
Correct.
Try to
Yes,
have
sir.
events. Okay. All right. I just needed that clarification. All right. So what's the county's recommendation?
County's recommendation is 30 days to achieve compliance, or $250 per day to fines to occur with a $84 administration fee.
Has there been any communications with the property owner? Are they in the process of seeking a post permit for the clearing of the property?
I did speak with him on December 2nd of 2025, and he said that, he had other types of permits to be able to clear out their USDA type permits, but he said that he was going to go to planning to talk to them about how he needed to go moving forward to proceed and get everything corrected. But as far as I have heard, he has not contacted planning department, and he has not been in contact with me since then. I did email him about the information that I had found online from Grant to Mr. Harrison, and I did not receive a response by email as well.
All right, thank you. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located on Rock Hill Road with the parcel ID of 12-1N-19-17-00-0001 0050 is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find that there is sufficient evidence to prove the following violations based on the testimony and evidence presented this morning: that there's violation of 1.13.00A development approval, 1.13.09C building permit requirement, 1.13.09F clearing permit requirement, and 2.02.00P RV and campers. I'm not going to find that there's a violation of 2.02.03 estate residential. I will find that there was previously, or there was evidence to show that a violation previously did exist on the property related to 2022-18 outdoor event ordinances. But that has been remedied at the time of this hearing, so no fine in that matter, on that particular claim will be imposed. However, in the event that there's a future violation of that same ordinance, that matter could be handled as a repeat offense. Now going back to the sections or ordinance sections of the code that there was a fine, I'll find that the property must be brought into compliance within 30 days. That's February 14th. 13th? Okay. February 13th. If the property is not brought into compliance on or before February 13th, a $250 per day fine will be imposed. In addition to the fine, there is an $84 administrative fee that will need to be paid regardless of whether the property is brought into compliance, and that $84 will need to be paid within 30 days.
Thank you, Your Honor.
Yeah, let me just note on here. All right, I'm noting on this order. I'm going to strike through both the estate residential and the outdoor events, but I wrote down in the section dealing with repeat violations that deals only with the outdoor events.
Understood.
All right.
Thank you.
That order's been signed. Thank you, sir. Next case is Casey Nunez, and that's 171 Long Lake Drive in Miramar Beach, Florida, case number 2501721. Is anyone here? Is Ms. Nunez or Mr. Nunez here? All right. Whenever you're ready.
Good morning. I'm Code Compliance Officer Georgina Hicks, and for the record, I'm submitted my final summary report, presentation, and testimony in reference to case 2501721. This property is in the unincorporated area of Walton County and is subject to the Land Development Code Chapter 7. The property is located at 171 Long Lake Drive in Miramar Beach, Florida, 32455. The property owner is Casey Nunez, and the violation cited is 2.02.00B2 for storage and utility building and 1.13.00A for development approvals. On 8/28/25, I conducted an inspection in reference to an email our office received about some kids' activity sets that with slides that were placed out in the right-of-way in front of the property. During the inspection, I observed the children's play set in the right-of-way, and I attempted to make contact with the property owner, but it was unsuccessful. During my inspection, I observed a structure with a tin roof in the back of the property that appeared to be in the setback. I left a card with my information as well as information about the items in the right-of-way and that needed to be removed onto the property out of the county right-of-way. Research showed that no permits were on file for the shed structure in the back of the property. On 9/9/25, another officer conducted an inspection for me and advised that the items in the right-of-way had been removed, but the shed was still present. On 9/9/25, a notice of violation was mailed via email and mailed to the property owner and posted on the property. On 10/2, I spoke with the spouse of the property owner and explained that the shed required a permit and would have to be relocated out of the setback. And I provided her with a number to the planning department as well as explaining the online application process. On 10/21, no permits had been applied for. When I reconducted an inspection of the property, the shed still remained in the same location. On 12/1 of 2025, a notice of hearing was mailed via certified mail, and on 12/15/2025, I spoke with the spouse of the property owner again and explained that the shed must be removed or permitted. I also provided her the planning department information. On 12/17, a notice of hearing was posted on the property and posted at the South Walton Courthouse Annex. Proper notice was given, prescribed by the code. As of today, no permits have been applied for, and the shed remains in the same location on the property. I'd like to submit my packet into evidence.
All right, that'll be accepted.
I'm requesting.
Hold on one second. A note in your report that when you made contact, let me find it. So on 12/15, you spoke with the spouse of the property owner, Ryan Taylor. She advised the property owner, Casey Nunez, is in the military and is currently overseas. Explain that to me. So we have listed as the property owner, Casey Nunez, correct?
Yes, sir.
Did you do any research or to check to see if Casey Nunez is in the military?
I did not.
And do the current occupants of the property, or they, I guess they represented that they're
She lives in the property.
they're
and
just living there?
She has a small little, has kids and things like that there, or their children that they have in common. It's what she relayed to me, and that he was gone, and she had presented herself as his spouse. But she lives there.
Okay.
And she even explained that she was going to work with the planning department to see about getting permits for it, and even act like she was going to be here today. So
I guess my question, and I don't know the answer, I know when you do a foreclosure, you have to check on whether or not the owner is active military and deployed. If there's no deployment, I think we would be fine. If they're deployed, I don't know that it's the same for code cases, though. I'm trying to think. You know, Brooke? You know what I'm talking about? Like, if they're active military and deployed, there's a federal statute that says you're not allowed to necessarily foreclose or repossess vehicles and things like that if they're on deployment. Now, if they're around, I think you can go. I don't believe so. Is that correct?
correct.
Okay, so it's just owned by
Casey
potentially,
Nunez.
Casey Nunez, who the claim is that it's, and I guess what I'm getting at is, I don't, having that question mark, I don't want to do something that would violate, federal law. I don't know that we would be, but I just don't know the answer to that. Okay, I guess with that question in mind, what I'd like to do is see whether or not the county can check on, and if you tell me, hey, here's the law, it doesn't apply in these situations, then great, I have no problem moving forward. If it does apply, then we need to know how it applies and what we have to do for that. And again, I'm thinking of it in the context of like property foreclosures. So this may not be applicable in this type of case. I just don't know the answer to it. I don't remember us ever coming across this before. Okay, yeah, if you want to look at it and see, and if you can get me the answer before we're done with the docket today, that's fine. I don't want to kick it down the road necessarily if we don't have to. So we'll put a pin in that at this point, and then we'll move on to the next one. All right. The next case is 25-01558. Property owner is listed as Mr. Lon Goodman. 71 Walton Gulfview Drive. I know we have Mr. Tatum here on behalf of Mr. Goodman, and we have the owner. Is this correct that it's in the Lon Goodman Revocable Trust? Is that correct? Okay, that's the owner. All right. All right. And are we ready? I know Brooke may be on part of this, and Mr. Tatum's here. Any ground rules we need to start with, or we're just going?
My position, I was going to allow the code officer to present his case, and I may have some follow-up questions at the end of that, unless
Okay.
Mr. Tatum has an objection to that.
Not at all. All right. Then that sounds good to me. Let's go ahead. Whenever you're ready.
Sir. My name is Justin Sloan, Walton County Code Compliance Officer. For the record, I'm submitting my final case summary report and testimony regarding case 25-01558. This property is located at 71 Walton Gulfview Drive, Inlet Beach, Florida, 32461. Parcel number is 273S181603000000160. Property owners are Lon Goodman Revocable Trust. This property is in the unincorporated area of Walton County and thus subject to the Land Development Code, Chapter 7, and the county ordinances. The violations cited are 1.13.06 post-permit changes, 1.13.09C building permits, and 5.00.03 building setback requirements. The complaint was a shed was located in the back left corner of the property within the setbacks. On 6/26/2025, I conducted an initial inspection and found an unpermitted structure in the side and rear setbacks of the property. On 6/26/2025, I sent a notice of violation to the property owner via certified mail, and on 6/27/2025, I posted a notice of violation on the property. The property appraiser's website shows the structure was not assessed until 2001. I spoke with the original builder of the home, Larry Gamillion, who stated he did not build the structure. The builder purchased the vacant lot and recorded a notice of commencement in November of 1997 and developed the property in 1998, but sold it in 1999. I advised the property owner he would either have to provide the permit for the structure, remove it, or apply for a variance. On 7/17/2025, a pre-application meeting for a variance was applied for but had expired. Another pre-application meeting request was applied for on 9/11/2025, but also has expired. On 10/30/2025, I received an email from Attorney Stephen Tatum, which stated that they had decided to take this case before the magistrate. On 12/11/2025, I sent a notice of hearing to the property owner via certified mail, and on 12/12/2025, I posted a notice of hearing on the property and at the courthouse. The property was not brought into compliance within the allotted time. As of the last inspection on 1/13/2026, this property remains in non-compliance. I request the magistrate find this property in violation. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
Okay. Any issues, Mr. Tatum, with, or any objections you want to make?
No, Your Honor.
Record. All right, I'll accept that into evidence. Ms. Davis, you have questions?
Yes, Your Honor. Officer, have you located any permits issued for the shed on behalf of the county?
No, ma'am.
Have you found any records indicate that code has been to this property before?
No, ma'am.
Is there any power, water available to the shed?
I'm not sure there's a fence covering it, so I can't really, all I could see is the top.
Could you evaluate whether it's attached to the home at all?
It's not, no.
I have no other questions.
Thank you, ma'am. Mr. Tatum?
Just a few. For the record, this is Stephen Tatum here on behalf of the owner, Lon Goodman Revocable Trust. Mr. Sloan, we met earlier, and you've been very cordial through email and helpful, so I do appreciate that. I've just got some questions for you. First, I'd like to know, how did you find out about the alleged violation?
We had a complaint filed.
Do you know who the complaint was filed by?
Yes, sir. I looked.
Can you tell us who that was?
We are not supposed to. I don't think I put it in my case file.
It's not, but if you know off the top of your head. Can you tell me if it was a neighbor or not?
It was the neighbor to
It was
the
a
left of
neighbor
the property, yes, sir.
to the left of the, so to the south of the property? Is that
Yes, sir.
correct? Okay,
Yes,
all
sir.
right. I'm going to show you something before we go any further.
Okay.
Okay, this is a property appraiser record card for Mr. maybe Rand and Bryant Balin?
Rand Balin, yes.
Balin, does that sound
That's-
familiar?
yes,
Is
sir.
that who you're looking for?
Yes.
Okay. I'm going to just give this to your attorney and to the magistrate.
So, Mr. Tatum handed me a copy of the Walton County Property Appraiser, excuse me, printout, appears from the website, and this is for the property 59 Walton Gulfview Drive, Inlet Beach, Florida, right? And
That's correct, Your Honor. And we can just call it,
we'll just Exhibit A,
that'll work.
Respondent Exhibit A, all right.
All right. If you would, are you familiar with reviewing these?
Yes, sir.
Okay, all right. I'm going to show you, for everyone, this would be on the third page. Can you tell me what, under the sales data, what date it says the Bollins purchased the property?
1/29/2025.
Oh, okay, I'm sorry. No, it actually is, go one below that. That's when they purchased.
11/30/2023.
Okay, so they've owned it for approximately 2 years. Did they give any reason why they wanted to report this property at this time?
No, sir.
No violation, and no concerns with the structure at all, besides they just did not like its appearance, is that correct?
Oh, he did state that after speaking to him, he stated that the structure was putting their stormwater onto his property.
Okay, all right. Did you see any evidence of that when you were on their property?
No, sir, but I haven't been there when it was raining. So.
Okay, did you visit their property, the neighboring property?
No.
Okay, let me ask you then about your pictures that you're in your case file. Where did these pictures, where were they taken from? That would be on, well, there's not page numbered, but the 626 initial inspection photos.
Those are from the road that's behind Mr. Goodman's house.
Okay, all right. So let me ask you this question. You never entered into Mr. Goodman's property, correct?
No, sir.
Okay. Have you seen a survey of the property?
No, sir.
Did you measure to see if this building was located within the setbacks or not?
No, sir, but you can clearly tell that on the aerials.
Are you aware that the property appraiser's website is not a survey?
Yes, sir.
And you're aware that there's a disclaimer on the page where you go to look at the map that says it cannot be relied on for those purposes?
Yes, sir.
Okay. So that is not competent evidence to determine whether or not this is actually a violation or not. That's not a question for you, that's a statement.
Okay.
Sorry. So in summary, you've never been on the property. You've not measured to see if this is a violation or not. You've relied solely upon the property appraiser's website, which says you cannot rely on us for that purpose.
Correct.
So, I mean, honestly, Your Honor, I asked this be dismissed. There is literally no evidence that we're in violation.
So are you only seeking a dismissal of the setbacks? Because there's two others for post-permit and building permit requirements.
Well, we can get into that. That would be to the setbacks, but we did, well, let me just continue.
Yeah, why don't
On
you
the permit.
continue? We'll deal with it. Yeah, I just want to make sure, because.
Understood. In your case report, you do say that you and I corresponded about permits. And that's
Yes, sir.
absolutely true. I don't remember what the dates were on that. But you discovered the same thing I did. There is no permit records going back that far.
Yes, sir.
From 2001.
Correct.
Let me back that up. In order to build the record, we got to do this. This is the property appraiser's card for the Goodman's property.
You're submitting this as Exhibit B. Any issues, Ms. Davis? Here's, it's a printout from the Walton County Property Appraiser for property address 71 Walton Gulfview Drive, Inlet Beach. No objections? All right, we'll accept that in as Respondent's Exhibit B.
All right, Mr. Sloan, on the second page, you will see a section called Extra Features at the bottom.
Yes, sir.
Can you tell me what year it says the utility building was built?
Doesn't say.
Look below it, on the line below.
I mean, above it, it's above that, 2001.
Okay. That's a fair objection. I will withdraw the question. But I will submit.
I think the document speaks for itself. We can, we can rely on it to the extent we can, that's at least what the property appraiser says about that. All right, go ahead.
Okay. So now that we have covered that, so back into, we do not have records of any building permits in the county from 2001. Is that correct? That you found?
Correct, yes.
Okay, all right. So we don't know if this building was permitted or not.
Correct.
Okay, all right. So again, Your Honor, that's my argument for dismissal of the permits. We don't know if it was permitted or not back in 2001. They've not provided any evidence one way or the other, and he just admitted he does not know.
Okay.
So rather than go through a dog and pony and pull up Mr. Goodman and put on our case in chief, I would just ask that you dismiss this for lack of evidence of either violation.
Well, I understand, and I'll, I guess, kind of take it under advisement. I'll allow Ms. Davis to do any redirect or any additional evidence.
Okay, let me see if
this is still, in my mind, the county's sort of case in chief.
Agreed. All right, let me ask a few more questions then, just to clear you up. Just for the record, you don't have any training in surveying?
No, sir, we don't.
Engineering?
No.
Okay, so as part of your code compliance training, is there any training in determining where lot lines are?
No, sir.
Okay. Prior to the violation or the complaint, had you driven up onto Walton Gulfview Drive at any point in the past?
No, sir, I don't believe so.
Okay, all right. On a daily basis, and this is something I've always wondered anyway, but it actually is pertinent to the case too. What is your daily patrol like? Do you go out actively seeking violations?
No, sir, we're only complaint based.
Okay, all right. Okay, that's all I have, Your Honor.
All right, thank you. Ms. Davis, any redirect?
Officer, so how far back have you been able to look at records for this particular property?
2000 records as far as what do you mean?
As far as permits to the property?
Oh,
What's the first permit that you could locate on the property?
I don't remember. Gotta have that. I didn't print that out. I had emailed the building department, and they sent me what they had, but I don't remember what it was.
Do you recall what it was for?
think it was only for the home, and I believe it was a bathroom remodel permit.
Permits that you're saying that you could locate for the property?
Yes, ma'am.
So you located no permits for this shed?
Correct.
No floodplain review for the permit?
Correct.
Were you allowed to go onto the property to view the shed?
I don't believe I ever asked.
Walton Gulfview Drive, is that a road with high intense rates of travel?
No, ma'am. It's off of 38.
I don't have any other questions at this point.
As far as, let me do it this way. Mr. Tatum, do you have any additional questions? Go ahead.
Just one more. To the point of permit records, in our discussions, yours and ours, or yours and mine, it was my impression, and this is what I was told by the building department, I don't know if they told you the same thing, was that their records did not go back as far as 2001.
Correct.
Okay, all right, just wanted to clarify that. Thank you.
So, just so I'm clear, there is could you find a building permit for the home that was constructed?
Yes, sir.
Okay. So there are records, at least for the home that's on the property. There's a permit for that you could find? Okay.
Mr. Sloan, is this what you're referring to when you say you found a building permit for the home?
It's just a notice of
Okay,
commencement.
all right.
Yes.
Since that was included in your case, I thought it might be this.
Yeah, I do see that notice of commencement for the looks like that was filed in 97, dated November 6th of 97 with Mr. Gomillion as the person who signed that notice of commencement. So that's what you're relying on to show as far as the main structure, the home structure.
Yes,
correct?
sir.
Okay. All right. Anything else from Officer Sloan or from the county related to this? Okay. All right. Any other witnesses on behalf of? So no more witnesses or testimony or evidence from the county. Do we have anything, Mr. Tatum? And then I'll just hear the final argument. Do you have any witnesses, Mr. Tatum?
I do.
Okay.
Before that, I do want to say on the record, I know you responded back to my email yesterday saying it was received, but I did submit you a memorandum of law as to our affirmative defense of latches as it applies to this case, just because of the inordinate amount of time between when the shed was placed on the property and the current complaint. I just want to put on the record, and you did receive that, correct?
Yes.
Okay, all right. And we still believe that latches should apply. I believe you'll hear,
Well, hold on. This sounds like argument. Did you say you wanted to present?
I do.
more
I
evidence?
just wanted to,
Yeah,
that's the
let's
reason I was about to stop myself.
Okay.
I'm going to call Mr. Lon Goodman. He is the trustee for the trust that owns the property.
All right. And was Mr. Goodman signed?
He was
or
previously
in?
sworn.
Okay,
Yes.
good. All right.
All right, Mr. Goodman, just state your name for the record, please.
Lon Goodman,
All right, and what's your address?
71 Walton Gulfview Drive, Inlet Beach, 32461.
Okay. Mr. Goodman, what year did you buy this house?
2018.
Okay. And to that point, Your Honor, my memo to you says he bought it in 24. That's actually the year that, or I'm sorry, 25. That's actually the year it was put into the trust. So that was my error. So you bought this house in 2018. When you bought the house, was there any particular appeal to that utility building being there?
Yes, most definitely. Since the house has no garage and really not an attic storage, it would be our main storage building to store anything that you would normally put in your garage, from bicycles to
tools and yard tools and other items.
Okay, all right. And is that the way you're currently using it now?
Correct.
When you bought the house in 2018, was there a privacy fence around your yard?
No.
And that would be on all sides? There was no fence at all?
There was a fence on the south and north sides but not on the back side.
So, to your knowledge, from when the house was built until you purchased it, there was no fence there?
Correct. There was never a fence there. That's what the owners told me.
All right. And when you purchased the house, was the shed clearly visible from both your road?
Yes.
And from the road behind you?
Right, other than bushes and trees.
Okay, all right. Unless you have something else you think I need to ask you, I'm going to say that's it. All right, all right.
Yeah, Mr. Goodman, in case the county has any questions for you.
Come on up.
Mr. Goodman, when you installed that fence on the property, did you get a survey to locate the fence?
The survey was done when I purchased the house, and we used that survey.
Okay. And how close is the fence to the shed?
I haven't really measured it myself either, but I would say, well, one side would be very wide. It's fairly close to it on the back side, and on the other side that it says, I'd say in the area of 6 to 7 feet.
So the fence, is that on the property line?
Our fence?
Right.
Yeah, it's just inside the property line.
It appears from the aerials, would you agree that the roof to your shed hangs over the fence in a portion of it?
That would be correct. Just to the edge of it.
I don't have any other questions.
All right. Mr. Tatum?
We also.
Yeah, this is for you. Just to clean up where she was headed with that. I'm going to pull up the aerial she just showed you, which was part of the package that was submitted by the code enforcement officer. And this is taken from the property appraiser's website. I'm not certain if you can see on this aerial where your fence is located, but I'm going to point to a fence, right? Or what I consider a fence. Is that your fence?
I would say where it's located, but if that's the exact fence,
Okay. All right. And
just so I'm clear, are you pointing to the fence that would be closest to the shed that would be adjacent to Cottage Way?
That would be correct, Your Honor.
Okay.
All right. And as this picture shows, does it show your fence running along your property line?
Yes.
No, and in this picture?
Oh, I can't tell where the property line is.
Okay.
The red line is the property line?
That is what the property appraiser considers the property line.
Okay. So if that's my fence, then I guess I have extra space behind there that.
Okay. All right. And you are not in any way trained as a surveyor, correct?
Correct.
Or an engineer?
No.
Okay. All right. That's all I've got, Your Honor.
All right. Thank you. All right. Anything else from Mr. Tatum?
I do have one other thing I'm going to put in, Your Honor. This is a letter from the neighborhood president, the HOA president for Cottage Way, which is the property that we were just discussing that's to the to the west. This is just really a letter of support saying there's not been any complaints to his association about it. I'm going to just put that in for what it's worth.
At this point, I have no way to authenticate this letter and whether he has the ability to sign this letter on behalf of the HOA.
I would just argue, Your Honor, this is a quasi-judicial hearing. You know, you give it the weight that you think it deserves.
Yeah, I agree. I'll accept this in as Exhibit C for respondent. I don't know that this isn't an issue dealing with HOA enforcement of covenants and restrictions. This is, but you know, I can take it for what it's worth. I'll go ahead and accept it in as Exhibit C for the respondent over the county's objection.
Okay. All right, and now as far as our case in chief, we'll call it, that would be all that we have to present to you besides our, you know, our legal argument on the latches defense and, you know, whatever I might need to say to rebut.
Okay.
Mr. Brooks.
Anything else from the county? And then what I'll do is I'll give Ms. Brooks her opportunity to speak on, and then give Mr. Tatum his opportunity. And just so we're clear and for the record, it's 3 alleged code violations, 1.13.06 post permit changes, 1.1309C building permit requirement, and 5.00.03 setback violations. All right.
And I really wanted to just focus on answering the latches and equitable estoppel issues that that was presented as far as legal argument goes, as far as the factual allegations and the evidence has been presented.
Well,
I don't want to belabor those points at this.
Well, before you get into that, can we address Mr. Tatum's first dismissal request as it relates to the setbacks? You have any, I mean, and if you don't have any arguments or anything on that, that's fine, we can move on. I was just going to give you the opportunity to speak to that.
I think as far as the county's perspective goes, I've never seen where it's a requirement for the county to create a survey on somebody's property in order to prove that case. So I think that's a standard that seems to be implied and seems to be an unreasonable standard. If I haven't heard anything countering the county's evidence that at this point the setbacks, you know, are standard setbacks for the property. Mr. Goodman testified that the fence that he erected, that it is just inside on the property line. You can clearly see from the pictures that's been presented, and he even testified that the shed, it's immediately adjacent to the fence that he erected on the property. It's clearly visible on all of the photos of how close the shed is to that fencing. If Mr. Goodman had a survey to present to Your Honor that said that the shed was not within the 7.5 feet of a standard setback, then that could be some pretty strong evidence. But at this point, the only thing we have is the pictures and his testimony that's been presented today. So as far as the issues with that were raised in the memorandum as far as latches and equitable estoppel, I had the time to look over some the cases that were presented by Mr. Tatum. The 2 main cases that I saw to be on point were Siegel at 198 Southern 3rd 773, and City of Eustis versus Firster 113 Southern 2nd 260. In Siegel, I think that's something that I want to make sure that we're clear on. That case, the court was very specific in their ruling. It specified that the only point that they're making is that latches could be an available defense. It did not make a ruling as to whether it was something that should have been done in that case. It really went through an analysis on other states' laws and whether Florida recognizes it and that kind of thing. But in that case, county officials were on site 3 times in the 12 years that the containers that were at hand, they were on site. So I think that's pretty distinguishable from where we're at. As on the city of Eustis, and in that case, that's something that common law defense, the court did say that it should have been granted. But in that instance, you're talking about a municipality that had decided to spend a very long time leasing the structures that were in question, collecting rent on it, even making repairs on it. So there was a lot of involvement of the city that then turned around and decided that they were going to violate them on a code case. So I think that's not what we have at hand in this case either. Now, I would point your honor to two other cases that I'd like to hand in. Monroe County versus Carter, it's 41 Southern 3rd 954, and Castro versus Miami-Dade, code enforcement 967 Southern 2nd 230. If I can take a minute to pass these out.
All right. Yep.
So in Castro, in that case, that was an issue that the courts decided that they should have allowed latches, but in that case as well, the county had issued permits at building 2 times for the built portion of this home. So the county had direct involvement into it and knew of what was constructed on this property. So, and I think the allegations that were made in Mr. Tatum's argument is kind of really akin to the Monroe County case, where the allegations are because it was listed on the property appraiser's website that the county had some sort of imputed knowledge about it. In Monroe County, they said, as a matter of law, mere notice to one independent office or agency is not imputed to another. So the tax collector's records, it can't be imputed to code. That's a totally independent government agency from what code does and the records that are kept between the two. So I don't think at this point that the equitable estoppel latches defense that Mr. Tatum is arguing is going to be appropriate under the circumstances and the cases that we have presented.
All right. Thank you, ma'am. Mr. Tatum?
I'll try to keep this brief, Your Honor. To the argument on, would you like me to address the setback argument for the dismissal?
If you wanna go ahead and, I know you had made that.
Yeah, let me start
early.
there.
Go ahead and start there.
Okay. As I stated earlier, the record evidence is a aerial picture from the property appraiser's website that testimony indicated the website includes a disclaimer saying it can't be used for official measurements. Other than that, there is no evidence or testimony that the property was ever entered, measurements taken, or any efforts made to determine where the lot lines actually were in relation to the shed. It is the county's burden to prove their case. It is not our burden to refute their assertions. They have not proved anything when it comes to the setbacks. There's no evidence in the record that supports their allegations. The same applies to whether or not the building was permitted. So that would go to both no permit and the post-permit changes violations that are listed in the violation notice. The evidence is that the county does not have records of permits going back as far as 2001. So we do not know whether or not this was actually permitted or not, as was testified to by Officer Sloan. As far as latches goes, the Monroe County case that Ms. Davis relied upon is distinguishable from our case. It, in a couple of instances. In the Monroe County case, the defendant in that case, her last name was Carter. And Miss Carter had, she was the individual who actually made the changes to her home that brought about the violation. We can distinguish that from our current situation because we don't even know who put the shed on this property in 2001. Mr. Goodman bought this property in reliance on that shed being usable because it had been there from 2001 to 2018, and he needed that extra room for his house. So we can distinguish that way. You can also distinguish it because the court in the Monroe County case puts a lot of emphasis, I won't say a lot, but they do emphasize that they distinguish themselves from the Castro case, their decision in the Castro case that Ms. Davis alleged or alluded to. And they distinguish it in saying that in this particular case, the Monroe County case, that the changes that Ms. Carter made to her building were a safety concern because she was leasing that area out that she created on the ground floor of her home. I can't swear to it, but reading between the lines, it sounds like there was probably concerns about the floodplain, and that since you couldn't build down there, most likely it was in a floodplain, and that was the concern. So that's distinguishable from us. There are no safety concerns associated with this utility building. So that's what I would say in relation to that. So we still request that that you dismiss all of the violations. But if you're not inclined to do that, that you determine that laches applies, that the county at least should have known that the building was there, and that it is too late now to bring this case against us, and they're stopped from doing so. With that, I have nothing further for you. Thank you.
Thank you. All right. I appreciate both sides, strong arguments, and brought up several issues. The in the event that I find a violation, what is the county's recommendation on this?
County's recommendation is 60 days to achieve compliance, or a $100 a day $100 a day fine to accrue with a $73 admin fee.
Sure. And again, this is only in the event that
you find a violation. If you do find a violation, we would request 90 days. I do understand their position that we had already attempted the variance process. One reason we ended up in front of you today is because the planner we spoke with was full of doom and gloom about actually achieving a variance on this. And so that was like, well, maybe we should look at this other option.
Understood.
So 90 days would be preferable for us.
Okay, thank you, sir. All right. Thank you both. Again, I'll close the evidence portion. I've accepted into evidence. I've got respondents exhibits A, B, and C. I believe that's all that you had. Is that correct?
It is. I would like to make that memorandum that I sent yesterday to you, to Mr. Corman, to the county attorneys. I did not copy Ms. Davis because I was not aware she represented the code compliance, but she has seen it obviously and has responded to it. So I would like that to be incorporated into the record. By reference, I have a copy we can put in if needed.
Ms. Davis, any comments on that?
As long as it gets submitted to the clerk,
Yeah, I mean, I think there's been argument on it. I mean, the case law is what the case law is. I mean, it would be like any other thing. I'm going to have to rule on it, so I guess, and it would preserve the record in the event either side decides to appeal the ultimate ruling. So I have no problem with it. Have you seen it? Yeah, okay. Just put it right here. We'll just put it with this, and we'll just we'll just mark that for identification purposes as respondents exhibit D is in Delta.
Okay. Thank you, Your Honor.
Yep. All right. So at this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 71 Walton Gulfview Drive, Inland Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Codes. I think, so let me address the setback requirement first, since that was the very first one that was brought up by Mr. Tatum as far as motion to dismiss. So I do believe you're correct in that the property appraiser's website, we can't use that line or, those lines that we see on there as we would equivalent to a survey. But I think that strikes both ways. So I think the county can't use that necessarily. But I also think when Mr. Goodman testified that he had placed the fence just inside his property line, I think I'm allowed to use common sense as well in viewing the photographs. And he did testify that at least a portion of the structure, the roof line, does either touch or go over the fence. Now, I wasn't clear on if that was the back fence, but I think, in looking at the photographs that were taken and that have been submitted, it does bring into question, at least in my mind, a potential setback issue. So with that being said, I believe that based on Mr. Goodman's testimony, being able to look at the evidence that's been presented as far as, and again, I'm not necessarily relying as much on the overhead as I am on the other pictures. Those would be the initial inspections, as well as Mr. Goodman's testimony that the fence that was erected was just inside the property line, and that the roof line either overhangs or is right above the fence. So in that regard, I'm going to deny the request and find that there is a violation or sufficient evidence to show that a violation exists related to the building setback requirements, 5.00.03. Now moving on to, and I guess I must address this on the latches argument since that covers all three. And I did read the case law, and I read your memorandum, Mr. Tatum, and I thought it was well put together. But I do see that the case law, as well as the arguments made by Ms. Davis, show that estoppel and latches you must show, those are reserved for special exceptional circumstances. And I also have concerns about whether or not we can impute knowledge from the property appraiser's office, which is a separate office, to code enforcement and Walton County government as a whole. I think it would be akin, in my opinion, that if the sheriff knew about something and didn't tell the property appraiser, can we impute that to the property appraiser's office? Can we impute that to the Board of County Commissioners? I think your argument would be better received if we were sitting here and the property appraiser was attempting to seek code violations against the Lon Goodman Revocable Trust. And because they are not here, or in the event you had a issue with the taxes that were being imposed or the assessments based on the property appraiser's review, I think that would be more well received. So I do find that the latches and the equitable estoppel arguments as a whole on all of these is not applicable at this time because of the, I don't find that you can impute the knowledge from the property appraiser to these other separate and distinguished offices. All right, so now we have the post-permit changes and the building permit. I did hear clear evidence that the county does not have records to show whether or not the structure received or didn't receive a building permit. The only evidence presented today was a notice of commencement to show that the main structure at least had begun construction back in what was that, 1997? I didn't hear any testimony, and I didn't receive any evidence to suggest that that is proof, or that there was any proof that this structure didn't receive a building permit at some time or another. So in reference to the building permit requirement, 1.1309 C, I'm going to find that there is insufficient evidence to show that a violation has occurred under that. As far as 1.13.06 post-permit changes, I believe because of that issue, it covers both of those. We don't know that the permit hadn't been issued, and since we don't know that, and there wasn't sufficient evidence presented by the county, I don't believe I can find a violation of 1.13.06 post-permit changes either. So with that being said, of the three alleged violations, I'm going to find a violation only for 5.00.03, and that's going to deal with the building setback requirements based on what I've stated already for the record. With the county's recommendation of 60 days to bring the property into compliance or $100 fine, and Mr. Tatum's request for 90 days to bring the property in compliance, I will give the owner the benefit of the doubt and provide 90 days to bring the property into compliance, April 14th. In the event the property is not brought into compliance on or before April 14th, $100 per day fine will be imposed. In addition to the fine, there's a $73 admin fee. Would there be an issue with paying that within the next 30 days, Mr. Tatum? Okay. And I don't think it's lost on either side that if Mr. Goodman wishes to present his survey from when he purchased the property that would show the location, there may not need to be anything. So, is there any questions regarding my order from the county? All right, Mr. Tatum, anything from you? All right, thanks again, both of you. We'll put together a case, and that'll end that. You're dismissed. Are we good to press on, or do we need to take a break? Talking kind of generally to the rest of y'all that are here. All right. Okay, I heard press on, so we're going to continue to press on. All right, that puts us at number 6, case 25-01-776. Property owner is listed as Stan Shipp, S-H-I-P-P. Property is 505 North Church Street in Santa Rosa Beach. Is there anybody here on behalf of Mr. Shipp?
I'll run look for him.
Okay, maybe he ran to the bathroom.
No, sir, I didn't see him.
Okay. So we know that Mr. Shipp was here? Did he? Okay. When did he leave? Like just recently? Okay. All right. We'll see if he comes back, but we'll go ahead and start. Mr. Officer Sloan, whenever you're ready.
Sir. My name is Justin Sloan, Walton County Code Compliance Officer. For the record, I'm submitting my final summary case report and testimony regarding case 25-01776. This property is located at 505 North Church Street, Santa Rosa Beach, Florida, 32459. Parcel number is 152S20331600000410. The property owner is Stan Shipp. This property is in an unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 1.13.00A, development approvals, 1.1309C, building permits, 2.02.00P, RVs and campers. The complaint was clearing beyond the 20% that is allowed per zoning district. BPR and building permits expired. On 9/27/2025, I conducted an initial inspection and found that land had been cleared in the middle of the property, an RV that had hookups connected, a large tent, and several trucks with trailers. On 9/27/2025, I placed a stop work order on the property. On 10/1/2025, I sent a notice of violation to the property owner via certified mail and posted a notice of violation on the property. On 10/19/2025, the property owner contacted me voicing concerns about his stop work order. I explained all violations and how to correct them, or if he didn't want to proceed with a BPR, that he would need a restoration mitigation plan. On 12/11/2025, I sent a notice of hearing to the property owner via certified mail, and on 12/12/2025, I posted a notice of hearing at the property and at the courthouse. Photos in your packet show the initial inspection and pre-hearing conditions, with violations still existing. I would like to submit my packet into evidence. This property was not brought into compliance within the allotted time. As of the last inspection on 1/13/2026, this property remains in non-compliance. I request the magistrate find this property in violation.
Sorry, I'll accept into evidence, the county's packet. I had my head down. Mr. Shipp didn't walk in, did he? All right. What's the county, requesting?
30 days to achieve compliance, or $100 a day per fine, or $100 a day fine to accrue with a $73 admin fee.
All right, thank you, sir. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 505 North Church Street in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to find that there is a violation of 1.13.00A development approvals, 1.1309C building permit requirement, 2.00.00P is impeder RVs and campers. Based on the request of the county, I'll require that the property be brought in compliance within 30 days. That'll be February 13th. In the event the property is not brought into compliance on or before February 13th, that a $100 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee that will need to be paid regardless of whether the property is brought into compliance. And that fine, or that administrative fee, will need to be paid within 30 days. All right, and I'm signing that order. Did I miss anything, Mr. Officer Sloan?
No, sir.
All right, thank you, sir. All right, our next case is CE 25-01712. Property owner is listed as Sierra Osman, O-S-M-A-N. The address is lot 32 off Mandy Circle in Santa Rosa Beach, Florida. Is Miss Osman here? All right, I don't see anyone standing. Whenever you're ready.
For the record, I'm Co-Compliance Supervisor Jennifer King. I'm submitting my final summary report, presentation, and testimony in reference to case 25-01712. The property is lot 32, Mindy Circle, Santa Rosa Beach, 32459. The parcel number is 14-2S-20-33170-000-032. And the property owner is listed as Sierra Osman. The property is in the unincorporated area of Walton County and subject to the Land Development Code in Chapter 7 and county ordinances. The violations cited are 1.13.00A development approvals, 1.13.09C building permits, and 5.04.04B5 driveway access. I'm presenting this case on behalf of Co-Compliance Officer Darnell Bennett, who has transferred to another division. On August 29, 2025, an initial inspection was conducted by Co-Compliance Officer Bennett and former Co-Compliance Manager Lynch. Multiple unpermitted structures in various stages of construction were observed on the vacant lot. A notice of violation with a compliance deadline of September 30th, 2025 was posted on the property on September 5th, 2025 and sent via certified mail on September 9th, 2025. On December 19th, 2025, an additional violation was cited for having two driveways connecting to a county-maintained roadway, each exceeding the allowable width of 10 foot. An updated NOV with a compliance date of December 29, 2025 was posted on the property along with the notice of hearing. During the posting, the officer briefly spoke with a male individual on site who stated that his father was in the process of submitting the necessary permit paperwork. He was advised to contact the code compliance using the number provided on the notice if he had any questions. The notice of hearing was also posted at the courthouse on December 19, 2025. On January 5, 2026, an application for a single-family residence was submitted to the planning department. As of the most recent inspection on January 13, 2026, the unpermitted structures remain on the property and both driveways are still present and had not been reduced in width. At this time, I would like to submit my packet into evidence. The packet includes photographs from the initial inspection and the pre-hearing follow-up inspections, copies of the NOVs and the NOH, along with the proof of mailing and postings, and a copy of the current property survey showing the structures in the two 15-foot driveways. I wanted to submit that into evidence.
All right, that'll be accepted.
Proper notice was provided. The property owner did not bring the property into compliance within the allotted time, and as of January 13, 2026 inspection, the property remains out of compliance. I request the magistrate find the property in violation.
And what's the county's recommendation?
Although the property owner has not contacted code directly, they have submitted an application in an effort to move towards compliance. We recommend granting 60 days to bring the property into compliance or imposing a fine of $100 per day thereafter, along with a $73 administration fee.
Thank you, ma'am. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of the law. I'll find that the property located at Lot 32 Mandy Circle with parcel ID number 14-2S-20-33170-000-0320 is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find that there has been sufficient evidence to show a violation exists on the subject property, specifically a violation of 1.13.00A, development approvals, 1.13.09C, building permit requirements, and 5.04.04B5, driveway width. I did see in the packet that there was a survey from Rare Earth showing that the access points are 15 foot in width, exceeding the now I want to say I've heard that there's 20 foot, but then I've also heard like 24 foot. I think regardless, it exceeds either one of those. But
Yes, correct. They would be allowed to have two 10-foot to equal to 20 foot, but if they have aprons, those would not count.
Okay.
And they still require a permit as well.
Yeah, because I do see an apron on here that would, but they make the measurement, at least on the survey, of 15. But that was brought up in another meeting that I attended, so I just was noting that. But regardless, it appears this would exceed whether it's 20 or 24 foot. So, so I'll make those findings that there sufficient evidence for those three violations. Based on the county's recommendation, I'll provide the property needs to be brought in compliance within the next 60 days, which would be all right, on or before March 16th. In the event the property is not brought into compliance on or before March 16th, a $100 per day fine will be imposed. Separate and apart from the fine, there's an administrative fee that'll need to be paid regardless of whether or not the property is brought into compliance. Property owner will have 30 days to pay that. All right, I've signed that order. Our next case, CE 25-01780. Property owner is Lot 15 Gulf Shore Manor LLC, and the location of that is 100 Montego Avenue in Santa Rosa Beach, Florida. Is there a representative for Lot 15 Gulf Shore Manor LLC? All right, not seeing anyone.
Just a small correction. You said 01780, but that was 01784.
Yeah, 01784. I may not have went all the way. All right.
For the record, I'm Co-Compliance Supervisor Jennifer King. I'm submitting my final summary report, presentation, testimony, and reference to case 25-01784. The property is 100 Montego Avenue, Santa Rosa Beach, 32459. Parcel number is 14-3S-19-25040-016-050. The property is in the unincorporated area of Walton County and subject to the Land Development Code, Chapter 7, and County Ordinance. The property owner is listed as Lot 15, Gulf Shore Manor LLC. Sorry, that was property owner was listed. The violations cited are 1.13.00A development approvals and 1.13.09C building permits. On October 4th, 2025, Co-Compliance Officer Neenan conducted an initial inspection following a complaint that the silt fencing around the construction site had fallen and fill dirt was washing onto the neighbors' properties. Officer Neenan confirmed that the silt fence was in need of repair. Contact was made with former job site employees who advised there was ongoing disputes between the contractor and property owner. On October 17, 2025, Co-Compliance Officer Bennett issued a stop work order and posted it to the property. After the building department received a letter from the contractor relinquishing the building permits due to the owner's failure to pay. A notice of violation with a compliance deadline of November 21st, 2025 was posted on the property and sent via certified mail the same day. The notice of violation was delivered on October 22nd, 2025. On December 19th, 2025, a notice of hearing was sent via certified mail and posted both on the property and at the courthouse. As of the most recent inspection on January 13th, 2026, no applications have been submitted to either the planning department or the building department, and the unpermitted construction completed prior to the permit being released remains on the property. As of today, no contact has been made with Joseph Harker, the registered agent for the LLC. At this time, I would like to introduce my evidentiary packet. The packet includes photographs from the initial and pre-hearing inspections, copies of the notice of violation, notice of hearings with proof of their respective mailings and postings, copies of the Sunbiz report, and the letter relinquishing the contractor from the building permit. Excuse me, I can drink.
All right, that'll be accepted. So besides the silt fence, to reestablish that based on the last inspection, that's not been done. I see a photograph here of on 1/13/2026 in the packet. I don't see a silt fence, or I see a silt fence on the left side of the picture that appears down, but then on the right side, the silt fence may be up.
It was also after the building permit was relinquished, it was brought up that they would have to go back to the planning department for a new development approval, depending on how long they went without an active building permit. And because we had already violated them for development approvals, I didn't want to renotice them for the same violation.
Well, I guess I can understand the violation of the building permit when it had been issued, that they didn't have the silt fence up. But I see that there's also the building plan and floodplain review. So that now that the permit, let me get back here to this letter. The contractor has removed from the permit so they're not performing any work. So
and the option to correct would be to either try to obtain building permits, but if they were sent back to
right,
the
they would have to
planning
get
stage,
they'd either hire another contractor to get and have that contractor get a building permit, or they would have to get one in their own name.
or remove everything and get a restoration plan because it was cleared.
Okay. All right, I think I'm tracking now on that part. All right. What's the county's recommendation?
Due to the property owner failing to attempt to bring the property into compliance, we request 30 days to bring the property into compliance, or a $250 per day fine, as well as an administration fee of $73.
All right. And have you, I think you may have testified to this earlier. What was the last contact you had with the property owner, or have you had any
We have
contact?
not had
Okay.
any.
I know you said you spoke with
The-
a representative for the contractor at the time, and there were some notes in here, but I mean, have you attempted to speak with the property owner about the issues and just no?
We had mailed them and we tried to locate a number, but we did not have a phone number.
All right. Thank you, ma'am. All right, I'll close the evidence portion of this hearing. If I didn't state earlier, I did accept into evidence, I think I did state earlier, but I'll state it again, that accepted your packet into evidence. I'll make the following findings of fact and conclusions of law. I'll find that the property located as 100 Montego Avenue in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida. And is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is sufficient evidence to show a violation exists on the property, specifically a violation of 1.1300A, development approvals, and 1.13.09C, building permit requirement. Based on the county's request, I'll require that the property be brought in compliance within the next 30 days. So February 13th. Should the property not be brought in compliance on or before February 13th, a $250 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee that'll need to be paid regardless of whether the property is brought into compliance, and the property owner will have 30 days to pay that. All right, I've signed that order. All right, our next case. CE 25-01865. The property owner is listed as Jeffrey Balderrama, and the address is 74 East Sadler Circle in Freeport. Are you Mr. Balderrama? Okay. Mr. Balderrama, I know you've been here a long time, and we appreciate you sticking with us. We're going to allow the county to present very quickly, and then I'll allow you to ask questions and present anything that you might want me to consider. All right?
For the record, I'm Co-Compliance Supervisor Jennifer King. I'm submitting my final summary report, presentation, and testimony in reference to case 25-01865. The property is located at 74 East Sadler Circle, Freeport, Florida, 32439. Parcel number is 32-1S-118-14000-007-021. This property is in the unincorporated area of Walton County and subject to the Land Development Code, Chapter 7, and County Ordinances. The violations cited are 1.13.00A, development approvals, 1.13.09C, building permits, and 5.07.09C, junk and debris. On October 24, 2025, Co-Compliance Officer Bennett conducted the initial inspection. Multiple unpermitted structures along with junk and debris were observed on the vacant lot. A notice of violation with a compliance deadline of November 28, 2025, was posted on the property on October 29, 2025, and sent via certified mail on October 30th, 2025. On December 19, 2025, a notice of hearing was hand-delivered to the property owner, and an affidavit of service was completed. A pre-hearing inspection on January 13th of 2026 confirmed that all violations remained and no applications had been submitted to either the planning or building departments. At this time, I would like to enter my packet into evidence. The packet contains photographs from both the initial inspection and pre-hearing follow-up inspections, copies of the NOV and the notice of hearing with proof of mailings and postings, and the affidavit of service.
All right, I'll accept that into evidence. At this time, Mr. Balderrama, do you have any questions for Officer King? Okay. Thank you, Officer King. You can grab a seat. All right, Mr. Balderrama, I'll be happy to hear any testimony or look at any evidence you want me to consider.
Okay. I am trying to comply with the violations as we speak.
Do you want to contest any of the violations, or are you just trying to come into compliance?
Trying to come in compliance.
How much time do you think it'll be before you would be in a position maybe to come into compliance? Again, best guess, I'm not gonna hold you to it.
A couple months.
All right. And do you understand what you need to do to come into compliance? Has the county advised you on what you need to do?
No.
Well, one of them is you have to get development approvals as related to certain structures that are on the property. So you'll need to get with the county on what those structures are that might need to get a permit.
Okay.
All right. And that'll cover 1.1300A and 1.1309C. Is that correct, Ms. King? All right. And then you have some issues, it appears, regarding storage of non-operating vehicles and some junk and debris they are claiming that needs to be addressed. Now, I did notice in one of the photographs there's a fence being installed.
I am.
Is this, would that, if there's a fence to screen it, is this one of those areas? I know some places you can screen, other places
Yes,
you
this
can't.
would be one that he could be able to screen, but right now the fence doesn't go all the way across, but we did note that the fence
Yeah, I
is
see
being
that.
erected.
So, do you understand that, Mr. Balderrama, that if you can erect a privacy fence that would properly screen some of the materials that the county has brought as far as junk debris or the inoperable vehicles, you may be able to avoid that violation?
Yes, sir.
Okay. Is that your plan to continue to build that fence?
Yes, sir.
Can I add one thing into that?
Sure.
Right now, it's a vacant lot, so he would need to get that development approval for a primary structure. If that was part of the whole game plan, I have not been able to speak with him, because if he does not obtain any kind of primary use, it's a vacant lot and he'd have to remove everything.
Okay. So we're not gonna be able to sort all the things out that this morning or this afternoon that you're gonna need to do to bring the property into compliance. But I do recognize, and it's based on your testimony, it seems as though you recognize there's some things that need to be resolved.
Yes, sir.
So, since it's been a long morning, I'm gonna go ahead and try to get you out of here. So, do you have anything else? What's the county's recommendation on this?
We'd be willing to give him 90 days.
All right. And in the event the property's not brought into compliance in 90 days, what's the county seeking?
$100 per day, along with a $73 admin fee.
Mr. Balderrama, that's, from my understanding, the maximum amount of time I'm allowed to give, which would be 90 days. And I'm more than happy to give that to you to try to get moving in the right direction and hopefully get this, get the property brought into compliance. Do you have any comments on the recommendation? Okay. All right. Thank you, sir.
Thank you.
All right. I'm going to go ahead and accept into evidence, if I haven't already said, the county's report. Oh, Mr. Balderrama, don't run off. Let me at least finish my part. I'm going to make the following findings of fact and conclusions of law. I'll find that the property located at 74 East Sadler Circle in Freeport, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find, based on the testimony and evidence presented, there is sufficient evidence to find a violation has occurred at the property, specifically 1.13.00A, development approvals, 1.13.09C, building permit requirements, and 5.07.09C, exterior storage of non-operating vehicles, junk, or debris. Based on the county's recommendation and my ability to provide the max, I will give Mr. Balderrama the maximum amount of time of 90 days. That's going to put us at April 14th. Okay, so on or before April 14th, the property will need to be brought into compliance. In the event the property is not brought into compliance, a $100 per day fine will be imposed. In addition to the fine, there's a $73 admin fee that'll need to be paid. Mr. Valderrama, can you make that within the next 30 days? Okay. So you'll have 30 days to make that, and you have to pay that regardless of whether or not the property is brought into compliance. I'm signing this order. Get with the county, and good luck to you, sir. Thank you. All right. Real quick, I know we're almost there. Is there Mitchell Detwiller? Okay, great. I know Miss Machado. Sorry, guys, I got y'all's hopes up earlier. Y'all are next to last. And then do we have anybody here for CLMJ? Okay, so we got 3. All right, great. We good to just press on? Y'all want to take a 5-minute break? All right. All right, let's keep going. Property number 10 on our docket, CE 22-01470. Property owner is listed as Mitchell Detwiller. Address is 288 Ellis Road. Is this? Oh, I guess that's okay. 288 Ellis Road, 112, Miramar Beach, Florida 32550. And who are you?
Robin Landa, the other property.
I'm sorry?
Robin Landa. I own the property as well.
Oh, so
My
you're
name
listed.
just didn't.
Okay. Well, hold on one second. Where's that one at? Do I have, let me see. I'm looking for your packet. Okay, I got it. All right, yeah, so I have listed Mitchell and Landa Detwiller on this.
Close enough, I guess.
I don't know.
I'm
Is
Robin
it?
Landa. On the
Okay.
deed, it says Robin Landa.
Okay. Well, we'll need to get that fixed. So, let me see. We have a copy.
I mean, here's an old letter from Walton County Code Compliance with both of our names on it, if that doesn't.
That's fine. I'll pull it up while we're going through this.
Okay.
We may have to, based on the outcome, well, regardless of the outcome, we'll have to update this order. All right. Why don't we just go ahead and start on the case, and then I'm going to look up, not to say you're lying and that you wanted to hang out all day over here for this, but we'll see what we need to do. All right. Go ahead whenever you're ready.
Thank you. Officer Harold Serrano with Walton County Compliance. For the record, I am submitting my final summary case testimony in regards to case CE 22-01470. Property incident is located at 288 Ellis Road, Unit 112, Miramar, Florida. Parcel lot is 302S214287000001120. Owners Robin Detwiller is the one that's on active here. We had Mitchell and Landa Detwiller on ours, so I think sometimes the appraisal is first, last, then middle. It could be
at least on the warranty deed that was issued for this property, if I'm looking at the right one, is we have a Mitchell Detwiller and Robin Landa, husband and wife.
Right.
Okay.
So, property is an unincorporated area, Walton County, subject to Land Development Code, Chapter 7, and County Ordinance. Violation cited at 1.13.09 building permit. Case was heard before you on 9/20/23, where the property was found in violation. Property owner was given until 12/18 in 2023 to come in compliance. For $100 per day would be imposed. Affidavit of non-compliance was completed on 12/18/2023, and the property owner was able to obtain compliance on 1/22/2024. Total fine that was reached was the amount of $3,500.
Okay. And that's number of days out of compliance is 35.
Correct.
All right. And so, Ms. Landa, you're here requesting fine reduction. Is that correct? All right. If you want to come on up. Does the county have a position on this?
Walton County Code Enforcement does not have any recommendations for fine reduction at this time.
Okay. Ms. Landa, what do you want me to consider regarding the fine reduction?
I would just say three things. Number one, this was, I came before you at that last hearing, that was, I guess, forever ago now, but, you know, I had been apprised in writing by code compliance that I did not need a permit. That was an email sent to me, which was left off of the record that was included in the case, but I have documentation to that. So that's number one. So of course I put this to bed, right? And then it comes and rears its ugly head 5 months later, right? Or 4 months later. So that's number one. Number two, I had to spend an extra $20,000 to redo work that had just been done. I didn't have $20,000 just to put out, right? You know, those doors that were not compliant, that, you know, I hired a contractor that I thought was trustworthy, right, had just been put in. They were brand new and they had to be replaced. So, and then the last thing is, I mean, this work, I had to get a new contractor. The doors had to be manufactured. They are not standard. They were not available. This all fell over the holidays. You know, I mean, it's a process. I was given 43 days, I believe. I mean, it took 30 days just to get the doors in.
Okay.
We did our absolute best, Your Honor, in light of the fact that I had to spend another $20,000. I mean, unexpectedly and really through no fault of my own. And I was apprised in writing prior to that, you know, I didn't need a permit.
All right. Well, yeah, and we're not going to relitigate the case today.
Understood,
we're
but,
here
you know,
on-
again, that's,
I
you
get it.
asked, so there it is.
Okay. So what would you request that the fine reduction, since it's your request, what would be your recommendation to me?
You know, in fairness, okay, I violated something. I was apprised incorrectly. I did do my best. You know, you do see it's within a reasonable amount of time, right? So, you know, if I had been given 90 days, I think I would have almost met it, right? I mean, I would have met it if I had been given 90 days. I didn't even know I had an option to ask that, you know? I had no clue. So, you know, again, I realize it's going to be nothing, but it's not going to be nothing, but, you know, I don't know, $1,000.
All right. All right. Anything else from the county?
I don't know. We don't
all
have
right.
any objection.
Okay. Well, I appreciate that, and I do recognize that this wasn't an exorbitant amount of time of noncompliance, and I agree. As you said, you know, it won't be anything, but what I'll do, because the county hasn't provided anything that they're against the code or the fine reduction at this point, finding the mitigating circumstances, I will reduce the fine from $3,523 to $750, but you will also have the admin fee of $23, so that's going to end up making the grand total $773. All right.
Thank you. I appreciate that very much.
So let me write that in here real quick. Could you pay that within the next 30 days, or would you need 60 days?
No, I could pay it today if I needed to, but.
No, you don't need to pay it today,
Good.
but I just want to give you enough time, so if you
Absolutely,
wanted
I
any more.
appreciate that.
All right, well then, if that's not an issue for you, then I'm gonna make it 30 days.
Okay, thank
Okay.
you.
And do be aware that if it's not paid completely within that 30 days, that the fine will automatically go back to its original amount.
Okay, and I have
So-
to wait until something else happens paperwork-wise to take care of that?
How quickly is this usually? 24 hours?
Hours.
Yeah,
24
so
hours,
24
12
hours, and then payment can be made at the code compliance office. So they have an office at the south end.
Okay.
Oh, okay.
Okay, I'll figure it out. I can go to
Okay.
the Santa Rosa place.
Thank you, Your
and
Honor.
pay it? Okay,
Yes.
cool.
All right.
Thank you so much.
Thank you. All right, our next one is Ms. Machado. And that's case number STR 25-00063. Sorry about that mistake, Ms. Machado. I know you're probably mad at me. All right, So this is also a fine reduction request?
Yes, sir.
All right. Whenever you're ready.
Good afternoon, Your Honor. For the record, I'm Walton County Code Compliance Officer Andrew Underwood, and I'm presenting a fine reduction for case CESTR 25-00063. Owner Amy Machado. It's for property located at 2472 Bungalow Lane in Miramar Beach, Florida. Parcel ID 24-2 South-42830-000-2472. This case was presented to the magistrate on May 21st, 2025 at the short-term rental hearing and found in violation of Florida Land Development Code 1.13.16A, failure to register. It was ordered that the property gain compliance on or before May 23rd, at which point, excuse me, a $500 per day fine shall accrue. The property gain compliance on December 4th, 2025. This equates to 195 days of non-compliance, resulting in a $97,500 fine. In your packet, you will find an order of fine reduction, as well as copies of the final order, order imposing fine, and the affidavits of non-compliance and compliance. Administrative fees for this fine reduction are $23. In this case, the property is income producing and not a homestead. A review of the enforcement record further reflects that the county adhered to all applicable statutory and procedural requirements throughout processing of this matter. Proper notice was provided, and there are no administrative errors on the part of the county. Based on the evidence and the adherence to due process requirements, the county recommends no fine reduction. If a reduction is ordered, the county recommends that the reduced fine and associated fees be paid within 30 days of the signed order, or the fine will be reinstated to the original amount.
All right, thank you, sir. Ms. Machado, if you want to come on up. All right, you've heard the county's recommendation, and I'm right that you said it was accumulated 97,000 is the fine, the accumulation, how many days?
Yes, sir, 97,500, it was 195 days.
195, all right, thank you. All right, Ms. Machado, this is your opportunity, similar to the last property owner. Be glad to hear anything that you want me to consider.
Thank you. I have a packet here. Would you like me to go ahead and present it to you now?
Yeah, what's in it?
So it is our notice of hearing that I'd like to go ahead and point out. We recently married in April of this last year, 2025, and we were in out of country the whole month of May. Okay. The notice of hearing was mailed to my California home, so I was unaware of the notice of hearing until I returned back to our California residence in June of 2025. Around that time, officer contacted me along with the tourist tax, asking me questions about our bungalow property because it was a short-term rental. They wanted to verify that the short-term rental was only listed on Airbnb and Vrbo and wasn't listed on any other sites for revenue capturing. I agreed, and I informed that to the gal. Officer contacted me later that month also, and I was under the impression they were in the same area because of the short term. It wasn't until I think our second call when he had told me that it was at that time that I was accruing fees or fines, and that I needed to go ahead and file for a certificate. When we bought the property, I was unaware of that. All of our properties right now are long-term properties, so I didn't know that we needed a short-term rental certificate. So at that time, I went through the website that the gentleman had asked me to go ahead and go through. I did that, and you'll see in this packet, I applied for I guess it's the wrong license, because I applied for multi-level, which ended up being a hotel and restaurant one. So I did that by July. Then when the officer called me back, told me I was still accruing fines, I let him know that I had applied for the license, and it was at that point that it was determined it was a wrong license. He put me in contact with Paul from the short-term rental certificate website, correct? That's his name. And they helped walk me through to get the right certificate. At that point, I was discussing with the officer the fines, which I did not know that it was up to $97,000. He said it was behoove me to go ahead and file the fines for the property. What'd you call that? For like it was $100. And
the original administrative fees?
Yes, the administrative fees. I did that along with, I did all of the vacation registration planning development fines along trying to bring the property into compliance, and that was done December 4th. All my affidavits and everything, along with the notice of hearing. The second notice of hearing was in August. I was already back here in our Florida residence, so with all of these notice of hearings going to California, I wasn't apprised or aware of the actual situation. And with that being said, as generous as he was to make sure that I was aware of moving forward of the certificate that I needed to obtain, I didn't waste any time obtaining that certificate.
Okay. Yeah, I'll be happy to take all that. I mean, I can take it at face value, but if you want to go ahead and submit that packet, I'll gladly take it if you want me to. I don't know that I need it, but again, I know you put it together. I'll be glad to take it if you want. You've heard that the county has no recommendation for a fine reduction, but in the event I do one, that is standard, that if the fine any reduced fine is not paid within 30 days, it automatically would be go back to the original amount. So as we sit here today, let's just take everything that you said at face value. What's your request as far as the fines go, and the reduction that you're requesting?
Honestly, I don't feel it'd be the who to have a fine attached to this, knowing that I had gone through all the right channels, was aware of the situation, and paid the fines to the county already to obtain the certificates.
Are you talking about the admin fee?
The admin fee, and then there was some late for the certificate. Well, I paid for the certificate twice because the first one was the incorrect one, and then the second one was for the initial registration, vacation rental, renewal, late fees, and so on and so forth.
What are those?
Those equated to $1,133.
That would be for operating previously without the registration. So
No, this one was initial registration for $425, so I paid that twice because I did it for the hotel one, and then the vacation rental registration renewal fee for $300 because it went over the time, and then the registration for the late fee is $375.
I'll call Mr. Josh Allen, the short-term rental manager, to the stand, and he does need to be sworn in.
Well, I'm just trying to confirm what those numbers are. If you can shed a little light, go ahead and raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, sir.
Yes, sir. So I think Ms. Machado is a little bit confused. The licensure that you went for is from the state. That's not from the county. The licensure that she stated that she went for and got the wrong one, that is from the the state. From our side is the registration. We have
from our side.
Well, that was the registration fee that I'm showing you right now.
Yeah, that is the correct fees based upon the multiple years of non-compliance plus the late fee that is assessed.
Okay, and how much was that? That's what I'm trying to.
It was
$1,133.
Say that again.
$1,133.
Okay. All right. So I've got that number written down. 1,001. Okay, and that was paid to Walton County.
Correct, sir.
Okay. And then we had some other fees, but those are from that license is to the state of
The
Florida.
license is a state license, and whatever taxes that's handled by the TDT, and I'm not privy to that information, sir.
Okay. All right. Great. All right. So Ms. Machado, you're requesting that you not pay any fine or any accumulated fines today.
Correct.
All right. All right. Anything else from either party?
I will corroborate that the first time I made contact with Ms. Machar was on October 22nd, and she was unaware of the fines occurring at that time. So, and she did take steps after that to gain compliance. So that is true.
All right. Anything else, Ms. Machado, based on?
No, I don't know if you need this, but I just wanted to make sure everyone knew that I had that up. So the certificate that goes on the house.
No, I don't need that for what I'm dealing with today, but we appreciate that. All right. Thank you both. All right. So at this time, I'll close the evidence portion on the requested fine reduction. Based on both sides or on both ends of the spectrum, I'll one requesting 0 and the other requesting, well, one requesting no reduction, and the other requesting, it reduced to 0. I'm not inclined to do either one. So in Machado's favor, or Miss Machado's favor, she will get a fine reduction. But I don't know that how happy she will be with it, but I will give her the opportunity or the benefit of a potential fine reduction if she wants to take advantage of that. So I do find that based on the testimony, we had 195 days. It's not disputed that Ms. Machado attempted to resolve this issue in a timely manner. It's unfortunate that she did get the wrong license, and those fines continued to accumulate after July of 2025. So with that being said, I do believe she's entitled, if she wishes to take advantage of it, fine reduction. So we have a $97,500 accumulated fines. I'm going to reduce that to an even $2,000 that'll need to be paid within 30 days if Ms. Machado wishes to take advantage of the fine reduction. There is a $23 administrative fee that will need to also be paid. Within 30 days. Any questions from the county regarding the fine reduction? All right, Ms. Machado, any questions? Sure.
County put a lien on our homes for the fine recoupment. How long is it going to take to get that lien off? Because one of the houses is right now in its last set to close.
I don't.
Is there a way, because we had to push this off, and the sellers are going to go ahead and renege on their contracts we were here.
Yeah, I have no control over that. Yeah, I mean, this will be in within 24 hours, right? So then, once you've made the payment, then I guess there will be some lead time. I can't tell you on what that lead time would be, but maybe get with the county on what can be presented to the title company to show that it's in the works or that you've paid it, and then maybe that'll be enough for the buyers. Yep. Okay. All right. All right. That makes us, thank you, Ms. Machado, and county. That puts us at the last one. This is CLMJ Rentals LLC, case number 2500130. The address is 118 Spires Lane in Santa Rosa Beach. All right, and who are you, sir? Okay, Mr. O'Neill. And you're representative for CLMJ?
Yes, sir. I'm one of the signs.
All right, whenever you're ready.
I believe Mr. O'Neill needs to be sworn in. Did you walk in late? Did you swear in the beginning?
Okay, yeah, let me swear you in real quick.
Okay.
Mr. O'Neill, raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, thank you, sir. All right, go ahead.
So I'm presenting a fine reduction for case number CESTR 25-00130. Owner listed as CLMJ Rentals LLC, property located at 118 Spires Lane, Santa Rosa Beach, Florida. Parcel ID 03-3 South 20-344009-00E-0030. This case was presented to the magistrate on August 26, 2025 at the short-term rental hearing and found in violation of Florida Land Development Code 1.13.16A, failure to register. It was ordered that the property gain compliance on or before September 25th, 2025, at which point a $500 per day fine shall accrue. The property gain compliance on October 30th, 2025, this equates to 35 days of non-compliance, resulting in a $17,500 fine. In your packet, you will find an order of fine reduction, as well as copies of the final order, order imposing fine, and the affidavits of non-compliance and compliance. Administrative fees for this fine reduction are $23. In this case, the property is income producing and not a homestead. A review of the enforcement record further reflects that the county adhered to all applicable statutory and procedural requirements throughout processing of this matter. Proper notice was provided, and there are no administrative errors on the part of the county. Based on the evidence and adherence to due process requirements, the county recommends no fine reduction. If a fine reduction is ordered, the county recommends that the reduced fine and associated fees are paid within 30 days of the signed order, or the fine will be reinstated to the original amount ordered.
All right. Did the original admin fee was that part?
Yes,
of
sir,
it?
that
Okay,
was paid prior to
All right.
this fine reduction hearing.
All right, thank you, sir. All right, Mr. O'Neill, you've heard kind of the county standard on this. What would you want me to consider, and what are you requesting as far as a fine reduction?
Your Honor, to consider reduction in entirety at most. What I have, if it matters.
Yeah.
Copies of text message between my property manager.
Oh, go ahead and go back there. I'm sorry. We're trying to record these, so if you, yeah. Go ahead.
Text from my property manager on the date, I believe August, wasn't in there, I missed by chance, was August 25th. I got a notice at the beginning of August. The hearing was August 26th, and of not registering for short-term rental. But I had moved in as my permanent residence on September 1st. Getting a divorce, put a house up for sale in Miramar, then moved into the 118 Spires upstairs, the retail space underneath it, and the business entity of CLMJ was in Dallas. My soon-to-be ex-spouse, I never received notifications of the hearing until I had one taped to the door. And I showed up the August 25th, and I don't rent this place out. It's not on I had 3 properties. And I told my property managers I'm moving in. I didn't know it had to be completely off the site. It was just marked out. And
Is that what this here is that shows inactive, I guess?
yes.
Okay.
Yes. And that was my understanding August 25th when I went to the office, spoke to a young man. He was awesome. He said, well, you don't have to come in tomorrow if it's taken off the site. I said, fabulous. And I have texts from my property manager, and I laid everything out. Okay, we will remove it. I thought everything was fine. Then I get a notification, as you see on October 8th, from Officer Underwood, that it wasn't, that I missed. And then you had set the hearing for September 26th, and I didn't show, but I had no idea. I didn't know that I wasn't in compliance. Then I lost my mind, contacting what you see there, property managers. They say it's still on. And moving forward, then they finally took it off. But when he said, okay, done, then it was off the complete site, like removed completely. I live there, so there's no reason to do this. I had rented it before, yes, then stopped. And then moving forward, I had 3 properties. They're all gone. I live in the one. This $17,500 put me as a lien against the property, and selling my last one, I had to actually pay all of it or the buyers wouldn't buy, so I could get out from underneath it. So I paid a fine just to get it done. I had to, out of the proceeds, but I can't afford to lose those proceeds. I have employees to pay. Wasn't my intent, but I tried to take care of what I could.
Okay, so I guess my question is, has a fine?
For clarity, yes, sir. 2 things. I'd like to correct the record. The hearing was on August 26th. So in September was your deadline. We gave you the 30-day extension to get this handled. And as far as this property did close on a sale, so the proceeds did go to, the fine has been paid. I was directed by the county to go ahead and bring it for a fine reduction, and Mr. O'Neill would have the opportunity to request a refund from the county commissioners in the future.
Okay, so I guess so if I reduce the fine and he goes to the county commissioners and they say we're not giving the money back,
yeah, that's I was advised by legal.
okay. Well, I guess what I'm getting at is, to me, it's equivalent of if you have a speeding ticket and then you go you pay the fine, then there's really no need for a hearing. You know, the matter is over for all purposes. Usually we would have these prior to you paying the money. So I guess what I'm getting at is, could this not just go to the county commissioners? But I don't know that they would want to hear it if it's supposed to come to me. Ms. Davis, do you have any comment? Were you the one who told him to come here after he's already paid it? Well, did you hear any of it? So apparently there was a fine that accumulated. This gentleman owned several properties in the county. Sounds like he sold all of them but this one. In selling one of them, he paid the accumulated fine. And then now we're here for a fine reduction on a fine that's already been paid. So I guess my question is, what can I reduce on a fine that's already been paid? Okay. Right, and that's my problem is I don't have authority to tell the county commissioners to give refunds or, you know, monies that have already been paid. I think that's completely within the purview of the county commissioners. If they want to give people back money, then fine, give them back money. What I don't want is a scenario where, you know, let's just say I give a fine reduction and say it's only $1,000, and then he takes that and waves it in front of the county commissioners and says, you owe me $16,500, right? So I think we're in a conundrum in the fact that this has been paid, and I don't know that I can necessarily unring the bell. I don't think I've got that authority. So that's why I don't know. And I understand Mr. Richardson. So let me do this. Let's let's continue this matter and let me speak to Mr. Richardson and find out kind of his thought process on why this. So as we sit here today, Mr. O'Neill, and I hate that you were the last on the agenda, I don't know that I can help you out any, even if I wanted to. But let me speak with legal from the county. It might be confusing. You have an attorney here and Miss Davis, but they've got other attorneys. And apparently one of those other attorneys is the one who advised staff on bringing this up. So I'm going to continue this matter till next month. What's the date on that? All right, so we're going to tentatively continue this to February 11th. That'll give me enough time to get with Mr. Richardson or Mr. Richards. It's Richardson, isn't it? Matthew Richards? Yes, yeah.
I think that the points have been made if
Yeah, I mean, I don't have a problem doing both of those. If Mr. O'Neill wants to appear, obviously he can.
I'll appear.
If you don't want to appear, that's fine. And also I would request that this one be put at the front of the docket or agenda, so we can try to address it. If it's not addressed beforehand, but if it's something, so I guess what I'm going to advise Mr. O'Neill is, someone's going to have to walk me through how I can even do this. And then the other part of that is, if you hadn't paid the money, then it's just you send a check in for X amount, right? But you've already paid the money.
If I hadn't paid the money, I would have lost the sale on a property
No, I
that would have
understand.
messed, and I had no choice on to do that.
Right, I get it.
But I didn't feel the fine was justified, but I had no choice.
Well, yeah, and I'm not here, and this isn't the forum to relitigate, whether or not, I think those are things that I consider for mitigation, but I'm just saying from a legal perspective, I'm having trouble figuring out, how far my power or authority goes in this situation. So let me get with the county and discuss with them, and we may be back here on February 11th, or we may not, so we'll find out. So at this time, I'm going to continue this to February 11th. As I said, I think to Ms. Davis's point, you've made your points. I did write on this. I'm going to go ahead and just make this part of the record. These text messages, and we'll make this Exhibit A.
I have two more texts that I didn't include.
Why don't you go ahead and pull those, and then
I can email them.
Assuming we have a hearing, yeah, you can either email them and give them to the staff if you're not going to be here on the 11th, or if you're going to be here on the 11th, you can bring them with you.
Okay, I can do that.
both.
I can do that.
Okay. All right, is there anything else before we move on from this?
Yes, sir. If we're entering additional evidence into the packet, I'd like to provide data pulls from 2 April 2025 and 20 November 2025. Both list the same address that all the notices were sent to, as well as the tracking history for the 3 items sent to Mr. O'Neill and the payment receipt that was completed on 30 October.
Okay. I have no problem. What I would ask, if the county wants to resubmit that packet with that additional stuff for the February 11th hearing.
Okay.
And then we'll just,
yes, sir.
Just remind me. All right. And then I'm going to give this to you, Gina, so you'll have that.
You can keep track of that.
Instead of me, and I wrote that February 11th when I was writing that out. So, Mr. O'Neill, I apologize. We're not able to but I think I've got some questions that I need answered before I can move forward on this. So, all right, so we'll move that one to February 11th. Any questions, Mr. O'Neill?
Yes, sir.
Okay, I appreciate you hanging out with us and staying here, but let me see if I can get some answers, all right? Anything else from the county on this one? All right, thank you, sir, you're dismissed. I have some orders to be signed, I'll do those offline, and, oh, yeah, that's right, great, sorry, almost, good deal. Nunez, did y'all find something on that? I was trying to Google it and look at it as well, but.
I do see, so yes, it's federal code. Yes, it has been adopted by the state of Florida. It's the Service Members Civil Relief Act.
Yes.
So really that goes to consumer protection type things. So it would be civil matters, civil court matters. It does not seem to apply to administrative matters, such as what's before your honor. Now, if say that this process continued forward, there was a lien assessed, and then a civil foreclosure action was begun, that's where that Relief Act would come into play. So, stopping short of actual civil court remedies, then I think at this point, Your Honor has the ability to proceed forward on just the administrative matter and assessing those liens.
Okay, that I just wanted to be sure. Like I said, I know that's out there. I didn't know how, the scope and breadth of it, but my cursory review as we were going through some of these, I didn't find anything that said specifically that it applied to assessment of fines and things of that nature. It does mention foreclosure, repossessing, and evictions related to leases. So I don't disagree with what you're saying. If somebody wants to show that I'm wrong, I'm glad to look at it. But all right, so we'll proceed with this one. I believe we were done with the presentation as far as that goes. Let me see. What's the county's recommendation on this?
I'm recommending that the property owner be given 61 days to remove the structure or obtain permits from the Planning and Building Department. If permits or removal is not concluded, then a $250 a day fee be accruing until compliance is achieved. I also recommend that a $73 administration fee be ordered as well.
Thank you, ma'am. What's 61 days out?
I didn't write the date, I just wrote the 61, so I'd be on duty.
All right, thank you. I'll close the evidence portion, and just for the record, this is case number 25-01721. Property owner listed as Casey Nunez, and the property address is 171 Long Lake Drive, Miramar Beach, Florida. I'll make the following findings of fact and conclusions of law. Find that the property located at 171 Long Lake Drive in Miramar Beach is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find there is sufficient evidence that there is a violation at the property, specifically a violation of Code Sections 2.02.00B2, storage utility building, and 1.13.00A, development approvals. Based on the recommendation of the county, I'll provide that property needs to be brought in compliance within 61 days on or before March 16th, 2026. In the event the property is not brought into compliance on or before that date, a $250 fine shall be imposed for every day that it's out of compliance. In addition to the fine, there is a $73 administrative fee that will need to be paid regardless of whether the property is brought into compliance. And I've signed that.